What is that? Read out.
The issue of maintainability of the repetition would be considered along with the aforesaid challenge on merits.
Yes. Aforesaid challenge on merit. Therefore, what I'm hearing now, only your maintainability of the repetitions and the challenge to the notice dated 19th May 2022 so far as it relates to creation of supernumerary posts for the work education and physical education. There is no ambiguity in the understanding.
There cannot be an ambiguity unless.
No, Mr. Bhattacharya, there may be.
My lord had asked me to remain confined on the question of legality of supernumerary posts. I am also confining to that aspect. But while confining, there are certain runover also. Therefore,
yes, maybe. Transgressing the areas.
Therefore, I just skip over since my lord is very particularly on insisting me. Now, then kindly turn to paragraph 9, which deals with the supernumerary.
But I'll come back.
No, Mr. Bhattacharya, please be here. Otherwise, what he is arguing, if you say.
Yes, sir. Mr. Bhattacharya will take some time.
No, maybe, but it is up to you.
Now, kindly state your name, jump to paragraph 9. Skip over first 3 lines of the said paragraph. Then, with regard to the government order dated 19 September 2022, whereby the government proposed to create supernumerary posts. Kindly underline this: government proposed. And the cabinet memo says, well, the School Service Commission proposed. These are very interesting feature. And whereby the government proposed to create supernumerary posts for assistant teachers, I say that the state government order came as a policy of the government for accommodating waitlisted candidates. That is also the government stand. The commission, merely being a recommending authority, has no role to play other than implementing the directions of the School Education Department, for which issued the notice dated 14th October 2022, which is merely a schedule for conducting and counseling of assistant teachers for work education, physical education. I deny that the notification referred to are in complete violation of Rule 12.4 of the Rules 2016. I say that Rule 12.4 deals with the upper primary teachers.
Misquoting. This 12.4 is misquoting.
Misquoting. 12.4. 13.4.
13.9.
That I have placed also on the last occasion. Then that means I deny that there has been any violation of Rule 13.9 of the Rules 2016, as the panels and wait lists were published according to the said Rules 2016. But this is a very important submission on behalf of the School Service Commission. Therefore, this wait list, my lord, is related to 2016 selection, where ratio 1:4 was maintained. With regard to the petitioners being called for verification after creation of supernumerary post and creation, I say the question did not arise that the supernumerary posts were created for leftover wait list candidates who are actually successful candidates who could not be recommended for want of vacancies. And my rule, my lord, prescribed the detailed method of, my lord, declaration of vacancies at the time of advertisement and final vacancy 15 days prior to final publication.
Yes, that Rule 8 possibly.
Yes.
Rule 8. Kindly explain this situation, this 1:1. Supposing...
I just give a Shiva. Now, my lord, I have vacancy, suppose X.
No, first of all, this supernumerary post would be, treated as vacancy.
Of course. So. But they admit that these wait list candidates, they could not be accommodated because there is no vacancies. Vacancies were notified as per the rules. And my lord, as per the notified vacancy, my lord, they have invited for further interview, for a further schooling or merit assessment, 1:1:4 ratio. If there are not 100 vacancies, they have to invite 140 people. By that process, the list is prepared. And according to the merit position, the top meritorious persons who goes to vacancies filled up. The rest persons who are called for interview are placed in the waiting list. Why waiting list? Suppose a person who was found to be in the merit panel within the 100 declines to join. Then, during the validity of the panel, person at the waiting list is offered.
No, whether this can be treated as vacancy.
Of course.
If it is treated as vacancy, then 13
9 has to be followed.
has to be followed.
But that they say, the consistent pillar stand of the
And
authority.
in that event, the petitioners had a chance of
Everyone had the opportunity, to get a call.
How then by the cutoff mark will be lowered?
These are the now new vacancies, and the persons who are waiting may not be in the waiting list which has exhausted. They are also entitled to participate. When there are a vacancy, then you have to fill it up according to the procedure laid down under the law.
Mr. Varja, make it clear. Now, waitlisted candidates, why the candidates have been put in a waiting list? Because there were not sufficient vacancies there.
And therefore, these vacancies become beyond the declared vacancies.
Beyond the declared vacancies.
If it is beyond the declared vacancies, then you cannot appoint from the said recruitment process.
How your chance come then? If it is,
this vacancy now we have created X vacancies, it's open, who are entitled to apply as per the EGB, apply for these vacancies.
So this is a natural selection process.
Normal selection.
Normal selection process. But in a situation where if you treat this as vacancies, if you treat these as vacancies, how your chance?
I will not treat this as new vacancy. They say these vacancies are created after the selection was complete, after the appointment procedure was complete. Therefore, these are vacancy creation. They say we have created this for the waitlisted candidates. Why waitlisted? Because they could not get chance in the declared vacancy.
Now, I want to understand one thing. How if it is treated as vacancy,
Of course, at least.
how the petitioner's chance comes?
Yes, but if it is a vacancy, then what would be the duty of the government?
To declare it in the new, take it in the new selection process. In this selection process, if these vacancies, this supernumerary posts are treated to be a vacancy,
then what you have to do, you have to invite 1:1:4 ratio, all the persons who are waiting. May not be the waiting list, but their standing might be below the so-called waiting list. But still, they would be without.
But they must have the beyond the cutoff mark.
Yes, might be so.
1:1.4.
Now, cutoff mark changes as soon as you create the vacancies. The cutoff mark was created for the purpose of filling up the declared vacancies. That cutoff mark cannot come for the purpose of consideration of new vacancy.
So you say that as soon as it is a vacancy, your whole thing
has to do afresh.
Including the fixing of the cutoff mark.
Absolutely. Everything would be changed. You admit that we created this vacancy to quell the administration. I mean the agitation. That is the admission in the cabinet memo. Since the people were agitating, to stop the agitation, we have decided to create post for the agitating group. Can the state do this?
At that point, আমাদের আর waitlist এর position same ছিল panel expert.
And since Milord the চুপ করে বসো দুজন বসো তো ঘাড়ে বোধহয় থাকো না। And since the wait list conception is related Milord inextricably with the selection procedure of 2016, this wait list has nexus with the select list. If the select list is complete, wait list Milord vanishes. Apart from the question of Milord expiry, the purpose of wait list Milord is completely abolished as soon as Milord the vacancies are filled up.
So creation of supernumerary indicates that vacancies have been filled up. There is no vacancy has occurred due to non-joining or otherwise.
But if non-joining Milord, then the person who is at the wait list, he will be offered. And
But
this
Creation indicates that there is no such situation.
vacancies are complete. We cannot appoint you. Don't agitate. We are creating vacancy for you. This is Milord fundamentally against the basic principles of Article 1416 and in violation of the recruitment rules. I shall take your lordship to law later. But I am trying to emphasize on the fact that this is the persistent stand of the state and the School Service Commission as well, that the vacancies were created for a particular section. It may be for a privileged section. I use this term.
Paragraph 9 টা পড়ছি।
Then may I complete this note, paragraph 9. They were dealing with 13.9, 12.4 was a mistake. They have also may not say. They have, however, just down the middle. However, I deny that there has been any violation of Rule 13.9 of the Rules 2016 as the panels and wait lists were published in accordance with the Rules 2016. This is, in my humble submission, full stop. You admit that you have published it. Therefore, exercise of power under Rule 2016 is exhausted. Then they say, and in the ratio of 1:1:4, with regard to the petitioners being called for verification after the creation of supernumerary post, I say that the question did not arise as the supernumerary posts were created for the leftover waitlisted candidates who are actually successful candidates who could not be accommodated for want of vacancy. Well, how could they successful? We are also successful because we could not be accommodated in the vacancies. Well, if there were vacancies were created, I create 20,000 vacancies. Everybody is successful. This statement of SSC is very interesting. On the other hand, petitioners, on the other hand, were unsuccessful candidates who were not even eligible for participating in the personality test. Because this personality test was vis-a-vis declared vacancy. If the vacancies initially was, which you have declared and subsequent vacancies, automatically you have been called personality test. Therefore, this statement of School Service Commission.
So it cannot be said that you don't have any interest
Well, I am most
in
vitally affected.
creation of the supernumerary
This
post.
is absolutely, if I may use some, the argument doesn't hold any water. This paragraph 9 of the School Service Commission affidavit is very important and interesting. Then kindly come to me, Lord. In paragraph 10, they are dealing with OMR sheets. I am not now troubling my Lord with that. No, actually.
You may have come back again.
I have to. I have to. Now, Lord, this is interesting. Kindly come to paragraph 14. I say, Lord, this is important. Because I had pleaded before your Lordship, which has been accepted by the division bench, upheld by the Supreme Court, that after the creation of this, School Service Commission filed application before the court saying that we have created this post to accommodate illegal appointees. As soon as we took up the point, they wanted to withdraw. The Honorable Court refused. They preferred appeal. Appeal Court giving reason judgment refused. There's no, it cannot be withdrawn. Now they are dealing that. With regard to supplementary affidavit, I say that the said supplementary affidavit has been filed annexing one can application so and so, which has been filed in connection with WPA so and so, Shondip Prasad and others, which has no connection with the instant heat application, as the case of Shondip Prasad deals with the selection of Group D staff, which is a totally different selection process. Moreover, the purpose of creation of supernumerary as prayed for in the said can application is totally different from the purpose of creation of supernumerary post. That I have placed with that cabinet memo, this stand that is betrayed that. As proposed by the government order the 19th May. Hence, the question citing the can application while challenging the government order does not arise. It may be noted that the Commission has given specific written instruction to the advocates to withdraw the said can. But the facts are out. But the cat is out of the bag. Now you cannot just say, I will put the cat again into the bag. Therefore, the both state and School Service Commission lot.
For a minute, a division bench judgment.
I placed that division bench judgment. এটা আমাকে এবার দিয়ে দিবে। But in this connection, I'll be placing that this is the division bench judgment. Lordship has seen so many repetitions.
Show me two paragraphs from this judgment which deals with the locus standi point.
Yes.
Paragraph 70 or somewhere I have seen.
No,
that.
the Honorable bench has dealt with subject wise.
Paragraph 128 onwards. Recording.
I'll kindly come to alert page 159. Maintenance. 158, what's the maintainability?
Where I wanted to.
Paragraph 128 under the heading maintainability. Having understood the parameters of the matters, this is very important, which my lord also not thinking, what is the parameter within which locus has to determine. Having understood the parameters of the matters, which we have to decide the issue of maintainability of the writ petitions needs to be answered. Persons opposing the writ petitions have questioned their maintainability. In order dated so and so, the Honorable Supreme Court enjoined maintainable writ petition have been questioned on the ground of delay, laches, and writ petitioners being at the behest of unsuccessful candidates who had participated in the selection process and failed. Various authorities have been cited at the bar on such an issue, which we shall consider presently. Milord, I am not detaining my lord with the authorities submitted by the respective parties. Then kindly turn to Milord, page 164. But I am not really detaining my lord with the issue of laches, acquiescence.
147.
Now kindly come to analysis of the cited authorities on maintainability. 146. Authorities cited at the bar have underscored the underlying principle governing delay, laches, acquiescence to defeat a writ petition to be estoppel and prejudice. In the facts and circumstances of a given case, if the writ petitioner is found to be guilty of such delay and laches so as to have allowed third-party rights to intervene and attain finality, can I underline this? Third parties' rights have been allowed third-party rights to intervene and attain finality, then such a writ petition is not to be entertained. Similarly, when the writ petition is found to be acquiesced in a particular course of action, he is held to be estopped from questioning the same. However, these defenses of delay, laches, and acquiescence would not have application when the existence of fraud is established. No appointment can be made after the expiry of the panel. As the panel is not a perennial reservoir of appointments. Panel is valid for declared vacancy and for the specified period. Now, this will have apt application before your lordship also. Appointment towards future vacancies cannot be made from the panel. Appointment made in violation of Article 1416 of the Constitution of India are nullity. Courts have no jurisdiction to direct appointment to be made beyond the validity period of the panel. I don't think your lordship need to go further on this particular issue. The nature of the writ petition. Paragraph 150, I just giving me the glimpses of facts in that issue. A candidate who had participated in the recruitment notification for third regional test 2016 for the post of clerk has filed so and so. He had averred in his writ petition that the board had issued a provisional appointment letter in his favor for such post on March 2020. He has stated that such letter was issued 3 days before commencement of the COVID pandemic. He had gone to school at which he was given appointment but was not allowed to join. He had prayed for a writ to allow him to join in the post of clerk. Writ petitioners in so and so alleged that they participated in the selection process for Group D. They have claimed that the authorities had acted dehors the 2009 rules by not publishing the fourth phase counseling list and not calling the petitioners thereto. They have claimed that the authorities did not prepare and publish the panel in accordance with rules and that the entire panel was full of discrepancies. They have alleged that the entire selection process lacked transparency. They have claimed that several candidates holding rank below them had been given appointment. Similar allegations here. They have given details of some of the persons who were ranked below them but given appointments. They have sought appointment to the Group D post and cancellation of the notification declaring the panel to be expired. But other factors are there, many things. And all, after having considered all this, the court says this is a issue is no issue at all. Then kindly come to me, Lord. Paragraph 160, delay on the part of the petition and maintainability, because they might indicate this.
So 163 thing. 160.
मतलब 163 on a on a purposive reading of the writ petitioners, one cannot arrive at the explicit finding that any of the writ petitions or the prayers made therein barred by law or do not disclose a cause of action. But I have been repeatedly arguing this before your lordship. The writ petitioners are entitled to approach the writ court with the prayers made on the basis of the pleadings as existing in the writ petitions. At the bare minimum, the writ petitioners allege misadventure by the authorities in the selection process. The writ petitioners are the participants of the selection process, albeit unsuccessfully by most, in respect of which they allege misadventure. They are entitled to a fair consideration in the selection process, a fundamental right under Article 14, denial of which they allege in the writ petitions.
166.
Then Lordship may skip over. Kindly come to paragraph 166. The nature of misadventure alleged is such that such allegation cannot be dismissed at the threshold or as not disclosing a cause of action to approach a writ court, or such allegation being barred by law must not be inquired into by a writ court. Quite to the contrary, if the statements made in the writ petitions are taken as true and correct, then they make out a case of transgression of fundamental right to be treated fairly in a selection process undertaken by the state authority. Whether the writ petitioners will ultimately receive any relief on the basis of the pleadings of the parties completed after affording the parties opportunity of filing affidavits and the prayers made in such repetitions would be a different issue. On the face of the pleadings contained in the writ petition and taking such pleadings to be true and correct, on the principle akin to consideration of an application under Order 7, Rule 11 of the Code, it cannot be said that any of the writ petitioners are barred by law or does not disclose a cause of action, and that any of them must be dismissed as not maintainable at the threshold. This was my argument in brief. Now, in this background, you have
You
to
kindly take the pain of just mentioning the paragraph numbers.
But I have
Mr. Dasgupta, have you taken a
Yes.
note of it? What are the paragraphs number?
128,
এক second,
একজন বলো
146, 147, 160.
যশোর লিখছে
Tell me.
জোরে বলো, জোরে।
146, 147, 160, 163, 164, 166,
167, 168.
yeah, 160,
These are the points.
157 and 160.
Therefore, here, my lord was kind enough to confine also the creation of supernumerary post. Now, state, my lord, in his affidavit said that we have administrative power. That is beyond constitution. Now, kindly, my lord, takes up the Constitution of India. Let us see, my lord, the executive power of the state. কি? কোথায় দাও তাহলে দেখিয়ে দিই। I missed it. This SSC, they filed with a supplementary affidavit.
No.
But this is of 19th February 2024. We kindly turn to paragraph 4. But if your lordship kindly permission, may I put on the hat?
Yes. Yes. Yes.
এই তো একটু জল টানতে হবে। But kindly come to paragraph 4.
এটা শুনিয়ে রাখো ওই ফাইল হলুদ ফাইলটা কোথায়?
Paragraph 4 of
এটা
19th February.
paragraph 4 of the supplementary evidence.
Yes, supplementary affidavit dated 19th of February 2024, affirmed by Mr. HON'BLE Raut. Paragraph 4. It may be noted that by an order dated 19th of May 2022, which is challenged before your lordship, the government created supernumerary posts for assistant teachers for class 9, 10, 11, 12, and for non-teaching staffs, group D, C, to accommodate those waitlisted candidates who were adversely affected due to rank jumping, supersession by some other holding a lower rank. Same order also created a total number of 16 supernumerary posts for physical and work education for all waitlisted teachers for co-education physical education. After the creation of said supernumerary post and subsequent receipt of 1600 vacancies, we'll underline this. Subsequent receipt of 1600 vacancies from the school education department. Now kindly just recollect the rules. When the final vacancies are approved by the state, then we'll have advertisements. On 29 September, the Commission published a notification in its website for conducting the counseling of the remaining waitlisted candidates. Therefore, admittedly, my lord, when the counseling begins, it means, my lord, they take these vacancies, my lord, which are subsequently created as part of the original vacancies and not declared. In the division bench judgment, lordship is pleased to note it that no appointment can be given beyond the declared vacancies and after expiry of panel. Which was held between 10th November and 16th November.
What is the meaning of remaining waitlisted?
Yes.
Remaining?
Some waitlisted, this is a huge scam. Some waitlisted who were ought to be waitlisted got already appointment. Even the investigation,
I can only derive a meaning from here. Of course,
they can
the
explain.
Commission has to explain. Remaining possibly indicates that from the wait list, somebody has already been given appointment.
That's somebody who were entitled to get because of someone has refused. Out of 100, 5 might have refused. Therefore, go down 1, 2, 3, 4, 105, they were afforded the appointment. Therefore, the waitlisted function became completely exhausted. Therefore, they say remaining waitlisted. And then the counseling process comes.
The rule prescribes how the persons or the waitlisted candidates would be
Yes,
appointed.
rule says.
Rule prescribes the procedure.
Rule,
There may
rule
be
says
one is to-
categorically it has been placed.
1:1.4.
1:1.4.
To that ratio, there'll be the calling for the counseling. From there, a main panel and a waiting list is prepared. Rule must have indicated or has prescribed
Indicates.
that how this waitlisted candidate will be given appointment.
That is prescribed in the rules. That as
Can you show me?
yes,
the
kindly turn to the rules. Rule is at page 248. At page 250, rule 13 is the method of selection.
252.
252, yes. Rule 13. This is the method of selection. There, my lord, sub rule 9 says
1:1.4.
then the final list is prepared. Kindly come to sub rule 11 is very important. The Central Commission shall also prepare and publish in their website a panel of candidates category-wise equal to the number of vacancies and category-wise waiting list for the rest of the candidates from merit list who were not included in the panel. From the panel, the Central Commission shall prepare region-wise list of candidates on the basis of option exercised by the candidates and publish in their website, provided that the written answer scripts of OMR shall not be reviewed or re-evaluated. Provided then second proviso, also that the number of qualified candidates to be called for personality test shall not exceed, mandatory, 1.4 times the number of actual vacancies published at the time of declaration. The rule was so compact to prevent any sort of extra mechanism. Rules are prepared to ensure that no bad water rushes in. Then kindly come to what would be the situation when someone in the list does not join.
Kindly declared at the time of result of written examination as per the clause B of sub rule 3 of rule 8.
You cannot go beyond this. statutory rules. State also cannot go beyond this. Now kindly turn to bullet 16. Validity of panel and waiting list. Both have validity. Each panel and waiting list.
This is admitted position. This is admitted position.
Admitted position, but fantastically they say it stands automatically extended. Affidavit says. Then my lord, 16 first proviso, provided that names of candidates shall not be recommended against any post other than the post applied for or against any vacancy which has not been notified. Where do we get authority to create posts for waitlisted? The waitlisting is prepared because of notified vacancies. And then you, in the affidavit, say, being a statutory authority, that they are qualified, others are non-qualified. If this is not, my lord, scam always doesn't mean, my lord, exchange of money. This is a scam when you deliberately violate the rules to accommodate XYZ. Then notwithstanding anything contained in sub-rule 1, a panel, waiting list, merit list prepared by each of the regional commission before coming into force, but that remains. Then 17, recommendation of candidates for appointment. My lord was asking me what is the mechanism. Well, may I place it, my lord? The regional commission shall hold counseling with a view
You are on rule?
17.
Yes, very well.
Now the regional commission shall hold counseling. Now that in the affidavit they say that we have started counseling for the waitlisted candidate, for which subsequently posts were created. Not had Shukumar been alive today, well, I don't know what would have written. Notwithstanding anything under sub-rule 1, a panel, waiting list and merit list prepared by each of the regional commission, I am not sorry, 17. The regional commission shall hold counseling with a view to recommending the name of the candidate from the list for appointment against each vacancy. Thereafter, the regional commission shall recommend the name of only one candidate against each vacancy depending her position in the panel and availability of requisite vacancies, and a copy of the letter recommending the name shall be sent through speed post. A recommendation letter shall remain valid for a period of 90 days from the date of issue. Well, all these aspects were taken into consideration. Then kindly come to sub-rule 5. If a candidate refuses to accept her allotment of post during counseling, or Central Commission gets information from any school or from the district inspector of schools or otherwise that a candidate recommended for appointment has not accepted the offer of appointment or joined the post within the stipulated period, or such a candidate refuses to accept appointment, or further scrutiny it appears that the candidate has misrepresented the facts. All these provisions are there. Then the Central Commission may do away with his name from the panel and will be deemed to have been depaneled and recommend the name of a candidate from the waiting list, strictly within the validity period of the panel and waiting list. It's a complete procedural letdown to prevent any hanky-panky. Now, here, Lord Shilkari, notice the commission has been empowered to, my lord, remove that person on a further squeeze. It appears that the candidate has misrepresented the facts. But here they say, oh, yes, there are mismatching. Now, because there are a mismatch, I create new posts. Law says if there are mismatches, remove them and give it from waiting list. you want to keep those mismatching candidates well valid happily, and without following the rules.
There is no allegation against the waiting list candidates that there
No,
is,
the allegation against the entire selection process.
so that is the other part.
No, therefore,
Now, we
yeah,
are,
but this waiting list is this outcome of the selection process. Waiting list.
I wanted to know, it's when the selection process in 2016 has got two parts. What is the reason why this was not included in the main selection process of
Because the
work education?
Milord, the
physical education?
vacancy selection procedure is well let down. Lordship has seen, Milord. I mean, this is again. Therefore, they say that the first declaration of vacancy at the time of advertisement, then further.
No, Mr. Bhattacharya, what I want to know, there is 9, 10, 11, 12, group C, group D in one. And why these two has been?
Incidentally, these petitions were not before the Honorable Court. Then,
Why these two separate?
this is the physical education and the work education is a different craft, different stream. In only confined to upper primary school. That's why this.
There was 9, 10, 11, 12, goes
Nine-
three group.
Just interrupting. Today, in 2025, the rules are one rule. 9, 10, 11, 12 and upper primary, one comprehensive rule.
25
In 2025. In 2016, the rules were different. Different means there were separate rules for upper primary.
2060 rules, but
Yes, your
but
lordship is
two are
looking at
different rules.
2016 rules.
Two different rules.
Yes.
Three different.
Therefore,
Three different.
That is
Thereafter, we have 2016 rules, 2019 rules, then 2020.
No, 2016, there are two rules for
Yes.
9, 10, 11, 12.
9, 10 separate,
one rule, Milord,
three rules. 9, 10 is separate, 11, 12
group
is
C, group D,
separate.
I am teaching.
9, 10 and একটা 11, 12
12
একটা upper primary.
All three.
Three rules.
Now, therefore, Milord, now the issue is Milord specifically confined to supernumerary post. Now, Milord, I was pointing out, my Milord, the supplementary by Mr. Amalesh Chandra Raut.
Paragraph 6 ছিল।
Milord, my ultimate argument would be, Milord, SSC, 19 February. That because of the Joshua দেয়া আছে ওটা।
কোথায়?
Hmm.
2024.
Now, I was at paragraph 5. After the creation of said supernumerary post, might be the risk of repetition. Therefore, the creation of supernumerary post is after the selection is over. On 29th of September 2022, the Commission published a notification dated 14th October on its website for conducting the counseling. Now, when you see the conducting the counseling of the remaining waitlisted work education, physical education. Therefore, on that date, you accept that the waitlist candidate, the waitlist was alive. And when you say counseling, therefore, you are going back to 2016 rules. My source of power is the rules, not beyond that. A copy of the notification annexed. In terms of the said notification, the counseling was concluded and the recommendation letters are issued in favor of all the remaining waitlisted candidates. However, by an order dated so and so, board was restrained. Then kindly come to paragraph 7. It may be noted that at a much later stage, the Commission, in a totally different set of writ applications challenging selection process with regard to appointment of as Group C, Group D, had filed applications for appropriate order. The said applications were filed in the month of September 2022 for creating supernumerary post to accommodate the candidates whose appointments were subsequently found to be invalid, so that there will be loss of job the said candidates would means a livelihood. However, the commission did not place the said application before the honorable to withdraw the said application. As I have already said before Lordship.
Paragraph 11.
Now, I kindly come to paragraph 11. It is abundantly clear now how far the state authorities can create misgivings that the supernumerary posts created by state by order dated 19th May 2022 are different from the supernumerary posts mentioned in CAN application.
Same only.
The supernumerary posts created by the state had already come into existence and were made for accommodating waitlisted candidates who had found their positions in the waitlist as per their merit. The supernumerary posts mentioned in CAN filed by the Commission have not yet been created. Now that in the background of this, I am compelled to take your Lordship to the Cabinet memo to show how far these authorities, either they got themselves confused or they are trying to confuse the whole world.
Another for cabinet.
এই তো ছিল এখানে লোকে ধরো।
Cabinet may select another.
Yes. Kindly
Kindly clarify this paragraph 11 first again.
yes.
I'm a little bit confused.
No, I'm confused. In the kindly takes me the application which they are referring to, that is also annexed.
19 May 2022 are different from supernumerary posts mentioned in CAN application of the Commission.
Yes.
So, on 19th May 2022, then when the application was found or filed?
This application was found by them.
This one, the earlier before the.
Yes, I'm that is part of annexure.
Canada. The September 20.
The CAN is a part of annexure. It was filed in September. It is September 2022. Specific date is not mentioned. 27 September.
Annexure R1 is the application.
Yes.
27th
September.
September 2022.
Now kindly come to paragraph 6 of the application. এখন আইনে ঢুকিনি।
So there, in addition to this, there are more supernumerary posts were created.
That is they want to say.
Such exercise means not to proceed with such exercise means
Not to proceed with the
creation of supernumerary posts.
no, such exercise means that they mean to say in paragraph 6 really follow. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified, it is humbly proposed that apart from giving recommendation and appointment to the genuine candidate as observed by this honorable court, by order dated 21st September, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid, since the matter was pending. But they all knew ultimately all this will be declared invalid.
But the paragraph 11, what I could gather, that there is one set of supernumerary posts
That-
under notification dated 19th May
There is no other.
2022.
But that is their misunderstanding. They probably wanted to communicate that Group C, Group D 1911 is different from physical education
But
work.
by one notification,
Yes,
such
kindly,
supernumerary-
kindly come to cabinet memo once again. I was thinking. This is very
Cabinet
important.
mode থেকে
Supplementary affidavit.
Supplementary affidavit আছে, cabinet memo আমাদের supplementary affidavit.
petitioner supplementary affidavit.
Affidavit dated 19th June 2025.
Now, is cabinet memo, again, I just refer to my lord. This is proposals, and I got it. Proposals for creation of supernumerary post of assistant teachers, including physical and work education. Therefore, this is the comprehensive cabinet memo. No separate. Then Lordship may skip over my lord, item 1, which relates to 9-10. Item 2 relates to 11-12. Item 3, rather item C, Group D, D, Group C. Then kindly come to E. For the teaching posts of physical education, work education, a total vacancies of 2,373. This is declared vacancy. Total numbers of candidates recommended was 2,194. The panel expired on 11 December 2019, and the decision is taken on 2022. They recognize this fact. Grievances on the said recruitment. A number of cases are pending before the Honorable Single Bench and Division Bench of the Honorable High Court, alleging that recommendations, appointments were given either in violation of merit or recommendation appointment given beyond panel and wait list. Same allegation. Allegation against all these appointments were same. In the meantime, one Shoma Das, the petitioner, alleged that in spite of her merit in wait list, she was not recommended, whereas candidate not even in the wait list got recommendation and appointment. The Honorable Court requested the Principal Secretary to look into the matter of the petitioner so that if possible she can be engaged in future. The School Education Department also considered the proposal of Commissioner of School Education with regard to the demand of waitlisted candidates, physical and work education for appointment in their favor. Now here is interesting development. The Shomadas issue was also raised before the Honorable Supreme Court. The Honorable Supreme Court said Shomadas was an exceptional one. We upheld that, but the rest we set aside. Which includes, my lord, the decision-making process of this memo is set aside. But the Honorable Supreme Court did not permit CBI investigation. That the cabinet memo, that was the view, the cabinet
Civil investigation to the extent of,
creation of supernumerary.
no, the observation is very, where is that second part order?
What
Order of
was-
the Supreme Court?
In respect of the creation of supernumerary post.
8 তারিখের order.
That the order is 8th of April. I'm reading out not loudly.
Sir, এই যে
We have Joshua copy আছে তো?
We have copies.
আচ্ছা,
তলায় দুটো Supreme Court.
আছে তো, থাকবে।
extra আছে।
কিন্তু,
না না ওটা নয় ওটা নয় ওটা নয়
Next one, another is there, দেখি এটাও দিন আর একটা
পেজের থাকবে।
মেন
ওটা মেন অর্ডার
3rd
এটা
April
নিয়ে
order,
নো নো 8 এপ্রিল
8th April order, 8th April order is there.
এটা দিন এটা দিন
Hmm.
April order is also there.
So, in paragraph 52 of our judgment, dated 3rd of April, it was held that the issue with regard to the direction for investigation by the Central Bureau of Investigation vis-a-vis the decision to create supernumerary post would be dealt with separately. Therefore, this is the issue. And there the Supreme Court says, next page, Milord, the last but one paragraph, having regard to the aforesaid discussion, we are of the view that the High Court was not justified in referring the issue of creation of supernumerary post pursuant to the cabinet decision for investigation by CBI. This was the direction issue. And the court says that this, we set aside this part, but this will not in any way affect. We, however, clarify that our observations and directions given in the present order are limited to the extent of directions for investigation into creation of supernumerary post and do not in any way.
But Mr. Bhattacharya, please see this, page 2.
Page two.
Perusal of the note dated May 5, 2022.
Yes,
Which note is referring to,
cabinet decision.
which makes out a case of cabinet decision.
Yes.
Reflects that it was recorded that the power of section 19 and this one may be used in respect of waitlisted candidates, but the same shall be subject to outcome of the pending.
Litigation, yes.
Section 19,
Direction by which they say section 19 empowers the state give direction to the School Service Commission.
very good. This case was taken by the cabinet decision such and such. It may be relevant to take note that clause 2 of Article 74 and clause
Yes.
3 of Article 163 of the Constitution of India, which specifically state that the question whether any, if so, what advice was tendered by the Council of Ministers to aid and advice of the President or tendered by the ministers. এটা ছিল না ওখানে? এটাও লিখে দিয়ে দাও, মাফ করে দিলাম। Yes, ministers to aid the advice of the President or tendered by the ministers of the cabinet to govern shall not be inquired into any court. However, clarify that our observation and direction given in the present order are limited to the extent of the direction of into the
Yes.
creation of to that cabinet decision.
There was no criminality. Now kindly takes up the Constitution.
ক্যাবিনেটটা পড়ছিলেন
Cabinet memo. Sorry, I was on the cabinet memo.
রাখো যেখানে ছিল।
Now, Milord, this is important because this goes against the affidavit by the School Service Commission. School Service Commission says that the supernumerary post was proposed by government, but the cabinet memo is otherwise. The third page proposal 2, item 2, proposal of Central School Service Commission and Commissioner of the School Education. But this runs contrary to the affidavit by the School Service Commission. The Central School Service Commission, the chairman of the Central School Service Commission, beat a letter dated 22nd April 2022, placed a report to the state government stating that 5,261 numbers of candidates have been affected by rank jumping. Admission of candidates have been affected by rank jumping in the first SLST 2016, third RLST 2016, Group C and Group D staff. 1932 post of assistant teacher for class 9-10, 247 post assistant teacher for class 11-12, 1102 posts for group C and 1980 posts for group D. And if all the similarly placed candidates like Shoma Das are to be recommended, then 5,261 posts are required to be created. Again, new post.
It is the proposal of the commission. What is the difference between that application and this
No,
proposal?
the affidavit says this is the decision of the state. I just once again said,
This was the proposal of Central Commission.
Central Commission initiated the proposal. What I mean to say, the Central Commission, not having appreciated that there are illegalities galore, the agitations were going on, therefore we propose this.
But then what is the difference between the stand of SSC
No,
disclosed in that
I want to s-
application?
Well, I want to submit to your lordship that all the authorities were really fighting against each other to shelter them. Because everybody knew this is illegal. But somehow or other I have to save my face. Therefore, all these things are coming. Now Shoma Das to be recommended like that. Now the Shoma Das Supreme Court has not got sanctioned, but not the others. But I would submit, Lord, that is my conclusion when I was concluding, that by virtue of the Supreme Court judgment, Lord, everything goes constitutionally. I'll come to that. Then the chairman, West Bengal School Service Commission, further, Videy's letter dated 25th April 2022 placed a report to the state government. Not I am skipping over the group C, group D because they will say different thing. The West Bengal Board of Secondary Education also confirmed the fact that such appointment of non-teaching staff beyond the list, as reported by the commission. The chairman of the commission further stated that for teaching post 9, 10, 11, 12, who do not feature in any list, either in panel or in wait list, should be cancelled by the commission without waiting for direction of the Honorable Court. Similarly, for cases relating to non-teaching staff group D, who do not feature in any list, panel, wait list, so and so should be cancelled. Then, Commissioner School Education, Videy's proposal dated 4th May 22 has proposed to create 1,600 numbers of supernumerary posts, break up 750 for work education and 850 for physical education, to absorb all waitlisted candidates of physical and work education, subject to validation of panel. Where is the validation of panel? How could the School Service Commission?
Debate at all.
How could the School Service Commission, without going based on recommendation, say we have recommended the names, thereby alluring without the unemployed youth to feel more agitated and agitate against the councils? These are the allurement. You yourself says that it is subject to validation of panel, and you know there was no validation of panel. But it requires, in my humble submission, very strict measure against these officials who are public servants paid out of the public exchequer. They are creating dissension. And dissension against the entire system. Now, department's views. Well, I'm straightway coming to the issue in question, 3 Roman 2. 1,600 supernumerary posts be created for absorbing all waitlisted candidates.
So the proposal was moved from the end of the
School Service
commission.
Commission. And then they say absorbing. Whom do you absorb? Those who are not in employment, how can they be absorbed? That will be fresh recruitment. The absorption in the service jurisprudence has different meaning.
The person is still that who has the recommendation was made by.
But I don't know who was then the chairperson. Recommendation was made in 2022.
Still he is the chairperson.
Siddhartha Mani.
এই অর্ডারের পরে রেকমেন্ডেশন হয়েছে মানে অর্ডার ওয়াজ
But this is the basic without foundation of cabinet decision, and the state says that we have administrative authorities beyond constitutional authorities. It's affidavit, but kindly come to Milord. Straightway, I take a lordship now. Question of law, facts, I have already Milord delineated.
পরে কিন্তু রেকমেন্ডেশন
তাই তো বললাম তা কি শুনলে এতক্ষণ Now will kindly turn to Milord Article 160.
চলে গেছে মানে ক্যাবিনেট ডিভিশনটা ঢোকানো এটা কোথায় ছিল? এরকম সাপ্লিমেন্টারি এভিডেভিট দেখি স্টেটে খাতায় লেখা আছে। এই দুটো এভিডেভিট কোথা থেকে বার করেছিলেন দেখুন। পিটিশনারের সাপ্লিমেন্টারি এভিডেভিট দুটো going to the constitution, can we take a break for?
Yes. Little more breaks, I can take a cup of.
Yes.
Kishore Chau.
হ্যাঁ চলো চলো।
Yes, written notes are, I will
Not
be invited.
written notes, I have not just little explanatory, nothing else.
Mhm.
Now, kindly turn to the state alert article 162. That Article 162 is the state's executive power. Extent of executive power of state, subject to the provisions of this constitution. The executive power of a state shall extend to the matters with respect of which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. Therefore, the executive power, which they say that we have executive power, cannot rise above the constitution. And the public employment is governed by Article 14 and 16. This is now a settled position, which is a part of the fundamental right. Therefore, whatever executive power you have, you can exercise in the field where you have power to make laws. And in this respect, my lord, you have already made law for recruitment of teachers. Therefore, you cannot have any other power beyond the laws which you have made in exercise of the Article 162. And vis-a-vis this, just I take the liberty to point your lordship the stand of the state. Kindly takes up once again the affidavit of the state. It's affidavit of state by the first affidavit, 28th of November, 2022. There is a fantastic way of claiming. Kindly come to subparagraph F. I just not place the important pleading or submission in the fourth line from the bottom of the same paragraph. Hence, it cannot be said that the teachers of a recognized aided institution are not in public employment. In fact, they are supporting in public employment. They were governed by Article 1416. Then, accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. And the larger framework of Constitution is only Article 162. And that Article 162 empowers you to work subject to the provisions of the Constitution. This is no power beyond the Constitution can be exercised. Therefore, they themselves have admitted that this has been done beyond the Constitution. Now, this is the constitutional position. Now, let us see how these
As
issues.
if they are suggesting that it is within the larger framework of constitution. So they are required to trace their such power within the constitution.
Yes.
Has it been explained anywhere in this?
Nowhere. No, there's no other power except Article 162.
You may not be knowing.
that I always accept, my lord. We live to learn. I cannot say that. But so far, so my knowledge that goes, Article 162 is only authority under the Constitution to exercise the executive power in the field which under that seventh schedule, second list, you can exercise. And in exercise of such power, you have already made the rules for recruitment. Therefore, you have no other power. Now, just for my interest, I will just refer to your lordship. Since this division bench has decided and the Supreme Court has upheld, few paragraphs relating to this supernumerary post. Now,
First, give me the paragraph number.
yes, I would just, I'm really tempted to read paragraph 350, 351, 352, 353, 4, 356, 357 and 350, up to 359 rather. I am tempted to make this, read these paragraphs which have some philosophical connection to society.
360 টা পড়বে তো।
And 360 also, yes. Now, the educational institutions have been admired, accorded special place in the society, and have been ring-fenced against the ills that may befall the society. Civilizations have made such attempts so that the future generation develops in an environment conducive for attaining the dreams of an individual student and caters to the holistic development of the student. Educational institutions are expected to produce better and evolved citizens who would be in a position to contribute to the society, nation, and to the mankind. Parents put their wards into educational institutions with the expectation that such educational institution imparts a level of education so as to assist the wards to develop into a better human being. Human beings are in control of any educational institution as in other institutions. If the teacher and the non-teaching staff of such educational institutions or even a portion thereof obtains appointments fraudulently, such teacher or non-teaching staff immediately forfeits his integrity, honesty, and his ability to impart wholesome education to a child in such an educational institutions. An educational institution must be protected against such elements attempting to percolate, let alone permeate into it. It is therefore imperative and in the beneficial interest of society that such elements are removed from an educational institution. Then important. SSC has filed Can 2 such and such you have placed before a lordship, seeking permission for creation of supernumerary post for the illegal appointees. When objected to by the writ petitioner, SSC had sought to withdraw such applications. Learned single judge had declined the request for withdrawal by order dated so and so. A special writ petition had been preferred where an order dated November 25, 2020 had been passed. In the two applications noted above, the learned single judge had directed CBI to undertake investigation in respect of the creation of supernumerary post. Division bench had refused to stay such directions. Supreme Court had, by order dated November 25, stayed such direction. Stay granted by the Supreme Court in November 25, 2022 was against the interim order passed in the pending writ petitions. Lest it be contended that we have not directed measures to be taken in respect of creation of the supernumerary post on final hearing of the writ petitions and the appeals, we deem it appropriate to pass necessary directions with regard thereto also. Investigation by CBI with regard to the creation of supernumerary post is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by SSC for state-funded schools, knowing fully well that such appointments were obtained beyond the panel and after the expiry of the panel at the bare minimum. Now, this is important for our purpose now. The enormity of such wrongdoing is accentuated by the fact that the illegal appointments are sought to be confirmed in educational institutions. Persons involved in such decision-making process therefore have exposed children to persons who obtain their employment through fraudulent means. Unless there is a deep and pervasive connection between the persons perpetuating the fraud and the beneficiaries thereof with persons involved in the decision-making process, such course of action in resolving to create supernumerary posts to protect illegal appointments is inconceivable. Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether such violations have resulted in criminal liability should be investigated into. Because criminal liability portion is stated by the Supreme Court, but Article 14, 16 has been upheld. Therefore, this supernumerary creation was also a part of the division bench judgment, which deals with the violation of Article 14, 16, which has been upheld by the Supreme Court. The next paragraph. Since at least a portion of the beneficiaries of the scam, that is to say that some of the persons who were appointed beyond the panel and after expiry of the panel and appointees submitting blank OMR sheets stands identified, it would be appropriate to direct such persons to return the benefits. I am not troubling my lot with that. Then, exception. During the pendency of these proceedings at para 360, Learned Single Judge had taken note of the plight of one candidate, namely Shoma Das, and directed registration of a writ petition number with regard thereto. Shoma Das has subsequently filed, in which an order dated April 18 was passed by a learned judge. There the learned judge had taken note of the medical condition of Shoma Das and requested the state government to consider providing her an employment purely on humanitarian grounds. In course of hearing of the matters before us, it has been submitted that the court should make an exception so far Shoma Das is concerned, since an appointment was purely on humanitarian grounds, which has been upheld by the Supreme Court also. We have considered the order dated so-and-so and find that request for consideration of appointment of Shoma Das was made purely on humanitarian grounds due to medical conditions of such person. Mrs. Shoma Das had been granted appointment by the state government purely on humanitarian grounds. Consequently, we propose not to disturb the appointment as state had granted her appointments on humanitarian grounds. She will stand outside the directions issued hereafter. On this discussion, ultimately, the Honorable Court was pleased to set aside the appointment. And the cabinet memo is basically based on Shoma Das's case.
No, so far the directions or to what extent the division bench considered this creation of the supernumerary post.
To the extent of Article 1416.
No, so far the affidavit or the application filed by direction based on that.
Yes, yes.
Whether the what is the subject matter of challenge in the writ petition? Somewhere around it has been covered by.
But in my writ petition here,
whatever the
challenge, our challenge is without
supernumerary.
No. Entire selection.
No, so far the supernumerary. Your challenge to the extent of 19th May 2022 notice, creation of physical body. Whether that notice, 19th May notice 2022, has anyway the division bench has.
No. Division bench did not really go into the nitty-gritties of 19th May notification. Division bench while found that supernumerary posts are created to accommodate the illegal appointees on the basis of the.
You have read somewhere, this is beyond the life of panel.
Yes. But this is here also. Kindly, I was placing the paragraph
147.
No, এখানেও আছে.
Is not a legal work. No appointment can be made after expiry of the ban.
Yes, paragraph 355. Paragraph 355, it says, below, that the appointments were obtained beyond the panel and after expiry of the panel at the bare minimum. Here also, the appointments ought to be given after expiry of the panel. And that expired immunity is stated to be violation of Article 14 and 16.
Where?
Well, next paragraph 357.
357.
Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether the violations resulted in criminal liability, but I am not troubling, that was said. Therefore, that apart, the other portion of finding that this violation of Article 14, 16 is upheld by the Supreme Court. Now, I will just place the order of the Supreme Court 1 second, Doctor. It is the third
3rd April, 8th April.
first order. যেখানে পুরো সেটা সাইড করে দিল।
First order to the third.
Now, the Supreme Court judgment, my lord,
Yes.
3rd April, where the court finds
Paragraph 45.
can you come to paragraph 46? Anyway, he wants me to read 45. It's not necessary 46 because Article 14, 16. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violated Article 14 and 16 of the Constitution. As such, all the appointments are cancelled. But this is a conclusive finding of the Honorable Supreme Court that violation of Article 14, whether you are found to be tainted or not, is immaterial. Here also, my lord, this notification itself is not a violation of Article 14, 16. And when on the affidavit they say we have executive power under the Constitution. Now, I may just point out once again, I have pointed out, Lordship, the affidavit of state. Affidavit of state, my lord, that paragraph is very interestingly drafted with all authority.
Election process held in 2016.
My lord.
A part of which has been found to be wholly polluted. How can the other part be so
How can it revive?
or like Ganges?
Yeah, that is not. How can it stay even for a single day? But if
It is your
Right. But if the supernumerary creation of post, they say subject to the pending of the writ petitions, they do not say that subject to the pending of the writ petition before Lordship, which was challenged after the supernumerary posts were created. But they say that all these petitions are pending before the High Court. I will show me that this state's stand first. Justice Chidambaram order first. Chidambaram. Chandrachud. The state stand was that the supernumerary post, though created, no appointment was given because of pendency of writ petitions. Therefore, they also knew. Joshua কে দাও একটা copy. দিয়েছো?
নিচে আরেকটা দিয়ে দেবো কি স্যার এটা দিন এটা মার্ক করা আছে
This is the first day order before the Supreme Court when state moved and got a stay. কত নাগাদ? It's the 7th main order.
প্যারাগ্রাফ 22 প্যারাগ্রাফ 22
Done.
হ্যাঁ স্যার ওই ডব্লিউপি নাম্বার কতটা বল পেন্ডিং 22
Yes, will you kindly come to me, Lord? Paragraph 21. Got it. On May 1922, the government of West Bengal issued an order creating 6,000 so-and-so supernumerary posts for teachers, non-teaching staff for absorbing the waitlisted candidates and directed that the appointment letters to such waitlisted candidates shall be issued in terms of the recommendation SSC subject to the outcome of the pending litigation before the High Court.
This writ petition,
Yes,
all these three writ petitions,
all these petitions.
5 writ petitions, all these 250 to 256 are before me.
Hey, কি বলছেন যশ?
All these 250 to 256 are before me.
WP number
এই রিপিটিশন গুলো তিনটে আছে আর তিনটে কোথায়?
আর দুটো এখন অ্যাসাইন হয়নি এবং এইটা স্যার আপনি পড়ে দেখেন এটা স্টেট বলেছিল যে এইগুলো
সেটা জিজ্ঞাসা করছি।
আজকের লিস্টে তিনটে আছে
Three matters are pending before your lordship and other three I'm told not yet
yet
assigned. বাদ দাও, যা আছে আছে।
তিনটে আছে ওয়ার্ক ফিজিক্যাল বোথ আছে
স্যার এইটাই নাম্বার হলো 25,056, এটা একটাই
ও
আমার
তাই,
হাইফেনটা হবে না।
oh my God. I am also outdated. The writ petition number is 250256, not hyphen.
ও আচ্ছা আচ্ছা আচ্ছা।
আমাদের এটা নম্বর কত?
250
Yes, this is the
Oh,
writ petition.
250, not 2, 25056.
Yes.
1, 2 is excess
That the hyphen is is unnecessary.
and 2 is also excess.
2 is also
25056.
yes.
এটা
Now, my lord, therefore, this is the stand. I'm just reading once again, Lord. During the course of hearing, this court has been informed that petitions under Article 226, this petition has been instituted before the High Court to challenge the order of the government creating the supernumerary post to accommodate the waitlist candidates. By an interim order, the government order creating the post have been stayed. Now, but this stay was not stayed by the Supreme Court. Since my lord, I had the privilege to
Was it prayed for?
because
at
they
one
prayed for that CBI investigation against the state for creating supernumerary posts. Please stay that
CBI inspection.
CBI investigation.
But since the stay is already there,
No argument, because that was the one, the sheet anchor of the defense. Since no appointment could have been given because of stay, therefore there is no criminality.
no, the background, I don't know whether at that point of time you were there or not.
But I was there physically. That's my difficulty.
No, not that. This matter. In this matter, two things proceeded parallelly. The one is this challenge. Simultaneously, the direction of the coordinate bench to go into the CBI inquiry as to the decision
yes.
of that. That traveled through division bench to an SLP
Yes.
before the Supreme Court. Supreme Court stayed, division bench has recorded. That SLC is pending. At that point of time, this challenge was shown. And Mr. Gopal Mukherjee.
Yes, my lord,
the
he said
learned
that
ad-
this issue might be.
No, I must say,
Yes,
he was a
very clear.
man of stature. When I put him this question, that if you can assure this court that this challenge
Would not
or
be
the power of state to create such post is under challenge here, this issue will not incidentally would be raised in that SLP. He then took specific instruction of his counterpart in the Supreme Court, said, no, that assurance I
cannot be
cannot.
given.
Matter was time to time deferred.
Yes, yes.
Even the state took a stand that no, we are not going to give any appointment now.
That's clear.
So why the matter was deferred?
But because of that.
Pending issues are there. In the meantime, division bench.
And then my lord directed the state to file an affidavit specifically stating that
Exactly.
whether this will clash with the Supreme Court determination.
They refused to.
SLP
Therefore, my lord, this stay by this court, my lord, in respect of appointment vis-a-vis supernumerary post was their, my lord, defense.
To get the stay of the
Criminal
CBI
investigation.
inquiry.
কুমার দাসের acceptance Supreme Court দিয়েছেন, ওটা একটু দেখিয়ে দেবেন কেন? paragraph 47, it will only restrict to Shumadash in that thing is back.
সে তো বলেছি অলরেডি मतलब
Supreme Court
I have already probably I'm repeating being
Prompted by.
poked by, I don't say prompted. The Supreme Court dealt with the Shumadas issue, paragraph 48.
Of 3rd April.
Yes, that's similar the base order.
Yes, lastly.
Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment held that the appointee Shumada shall be allowed to continue on humanitarian grounds. That's important. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. Therefore, my lord, many, kindly don't take it otherwise, many dramas were created in the court of the Supreme Court. Certainly, my lord, some visually disabled persons, they were brought in court to argue, in spite of their senior counsel having argued. The Honorable Chief Justice heard them and said, I am not going to give you benefit. And that's the finding at page 48. Shoma Das is exceptional. She was suffering from cancer. The court will not felt if some concession can be given. Therefore, that cannot be, my lord, a ground. That's why I say that will really contradict the main finding of rule of law. That is paragraph 48. And rule of law is Article 1416. And the state in its affidavit firmly says that we have our administrative power. I had pointed out to your lordship, note, I again point out, my lord, that this is the stand of the state at page 8 of their affidavit, subparagraph F. ওই যে দর্শক কাছে আছে 28 নভেম্বর দর্শক দেখালাম তো এই মাত্র ও নামিয়ে নিয়েছেন
আচ্ছা আমার ইয়ে যা একটা কথা বলতো হাতটা ওভাররুল করলাম আছে হাতের কাছে
subparagraph F. E, you could have placed, I am not troubling, my lord. They say the validity period has expired is an irrelevant consideration for creation of supernumerary post. This is where, yes, that is subparagraph E, last line. Subparagraph E starts at page 7, continues to page 8.
আচ্ছা
State, having made statutory rule, now says that is immaterial consideration. Then it is stated that subparagraph F is very interesting. This is source, they say. Last 3 lines. Accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. This could have been a new addition to the constitutional jurisprudence. Statute maker says that the statutory empowerment is immaterial. I have higher constitutional authority. What is this? Article 162. What the Article 162 says? Subject to provisions of the Constitution. You can take a decision in the field which empowers you to make law. And having made law, you take a stand saying that this is immaterial.
is it lack of understanding or to save a situation
To create more chaos in the society, not to save a situation. Lordship can take judicial notice of the fact that this has created huge chaos in the society. I do not travel beyond this, but this has everybody must have taken note of this fact.
Who is at the receiving end?
Bikash Ranjan Bhattacharya. Why did he raise this issue before the court?
Or the
Why did
candidates?
he argue that the entire panel should be set aside? He should have argued that the corruption should be prevailed.
So ultimately, the candidates.
Candidates, my lord, ultimately they are misguided people. Anyway, I restrained myself, my lord, from making this statement. Therefore, the stand that we have a constitutional power, my lord, belies the specific words mentioned in the Article 162. There is no other power by which state can, my lord, exercise executive power to do something. Now, the next question will be whether the judicial review is permissible. That point has been mentioned and taken by the court to judicially scrutinize the order passed by a cabinet. It means that if the cabinet tomorrow says that I let annul all the terrorists from who are imprisoned free, that decision cannot be reviewed. That's the stand, but that's not the law. I will take a shift in law. তাহলে পরে হবে
জিজ্ঞেস করুন করতে গেলে
Just,
স্যার
just
কোনো মাঝপথে
প্যারাটা থেকে প্যারা 37 ওটা 22টা বললেন প্যারা 37 স্পেসিফিকলি বলা আছে যে ওরা প্যারা 37 ওই দিন ওরা
যখন বলি তখন বলো না কেন
আমরা তো বললাম যে দুবার ফ্রন্ট করি
ঠিক আছে
স্পেসিফিকলি বলা
বিপি সিঙ্গল ওয়ার্কার
বিপিসি 2010 666 বিপিসি
কি আছে কি বলে
Did you cite that 2006 to SCC, the Vagela's judgment?
yes not in that matter
In some of the Article 16, which finds place in the part 3 of the Constitution relating to a fundamental right,
Right.
provides that there shall be equality of opportunity of all citizens in the matter relating to employment or appointment in any office under the state. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in the public offices. The word employment or appointment cover not merely the initial appointment but also other attributes of service like such and such.
but it was cited blood by me in Darjeeling matter
Yes, you had cited,
Blood-
but I have used it in another matter.
there are all
In Arjikor matter, I have used it.
similar judgments are only common in both matters
So Article 14 and 16 ultimately has to be adhered to.
but it's a fundamental right Milord, no one has any authority, Milord, to act in breach of fundamental.
162 does not give that much of power.
It starts saying subject to provisions. The constitution makers knew that may at some point of time, some people may come to power and they say, we are the monarch. Therefore, we can do whatever we like. And Ambedkar said, don't forget, we have a written constitution. We have a limited government. These issues, Milord, were discussed during the constitutional debate. That we have a written constitution and this is a limited government. No one has authority to act beyond constitution. Now, Milord, the heated debate is going on. Lordship is aware. The Supreme Court has said that even the governor and the president doesn't have the ultimate discretion to sit over the decision. They have to give a decision within a certain time. Normally in Madras governor matter, the president, Milord, has been pleased to, Milord, make a reference. Supreme Court will reject it, I am sure.
Here, even the legislature has framed a law, has legislated a law,
The field is occupied.
occupied field. Now, what is this saying that it should fall under larger framework of constitution,
know.
not, so he is given by the
This statute.
legislative field goes banks on the constitutional provision. That is under Article 62. 62 limits the power subject to the other provisions. So now you will be citing judgments now?
Yes, I will say.
Can we continue when?
Whatever time your lordship allows me.
Because I don't know who is for the state now.
Advocate General was there.
Very well, because this week it will not be possible for me to accommodate. Let me come back with a fresh mind.
Where are you going?
Andaman circuit, then I will take. Let some fresh air come.
Anyway, subject to court's convenience, lordship.
Because I know that this will be interruption on your argument, but I need to close down it very quickly. So what about, you would like to cite some judgments now? This is
So the facts are now, so far I am concerned, clear. I shall not give authorities.
you have
because
given
many-
outline of it in these 2 pages.
Not today's argument. Today's argument I shall give next day. This is my first day argument.
You make
Action with
make it and give it to me so that I can go through it
action with
and we can avoid repetition.
no repetition. এরপর আরেকটা পাতা আজকেটা দিয়ে দিই।
একবার শুধু প্যারা 37 একবার দেখে দিন।
Yes.
একবার প্যারা 37 একবার
Please, Miller.
একবার স্যার
But my juniors again will prompt me. I am just in paragraph 37 of first this order. The court has been Supreme Court pleased to record. Paragraph 37. I am reading out. Mr. Rakesh Dwivedi with Mr. Neeraj Kishan Kaul, senior counsel appearing on behalf of the state of West Bengal.
7 July order, first day order, 7
3rd April order,
7 July.
7th July.
7th July নাকি?
That is day,
In
first
July
day.
2025.
That is from the June.
7th May. July and May.
But he is perhaps reading that portion where Miller they submitted to the Honorable Supreme Court that no appointment is going to be made.
Pending writ petition.
7th May.
দরকার 7th May. It's all right.
Yes.
Pending writ petition.
But it's-
বলে দেন।
Yes, I have.
That seems
That no appointment, this council submitted appearing for the state that no appointment whatsoever has been made in pursuance to the order of the state government dated 1922, which in any event forms the subject of a pending writ petition. এটা আগেও দেখেছি।
Where here you are from?
The
Where?
paragraph 37 of the order,
This is order dated,
7th of May, first order wherein
but the SSC affidavit has already said that recommendation has already been made.
yes, the recommendation was made but not appointment.
7
No
pending.
Appointment. The recommendation appointments are different.
Given, no appointment given. Therefore,
Now,
so yes.
it is my as a
What? Tell me. What is? Tell me what you want.
Miller, kindly do not Miller,
Tell me, na.
I am trying to emphasize that Miller, one order is there which I will invite my senior Miller to distinguish because the challenge thrown to this entire process at some point of time, Miller, he had the occasion to represent us in 2019 and the challenge failed. I am handing over a copy.
At a time, you
At
the time.
The issue is I'll hand over a copy of the order. Milord, when he is going to make his submissions, I will request Milord because there is a complete controversy, Milord, going on inter say the Milord applicants because Milord it is an
No, I understand. He appeared once for
he
the,
have, not only he Milord they visited the place
Oh,
after those things are there.
very well. He will answer to that. Raise it in
we
reply.
still say without, we have said that the appointment
So
should
the
be
thing is,
made
Milord, Mr. Bhattacharya had
following
the
the-
occasion to appear for us, for some of us, not all of us.
not to seek illegal appointments.
Yes, question the appointment process.
Yes.
15 September.
কবে? দাঁড়াও।
15 September morning From the morning.
For the morning or the whole day? Philosophy kindly go ahead.
15th September.
Go ahead, go ahead.
Yes, Mr. Ghosh,
And if you not mention an urgent motion of code number 90, you of the
please
fact-
excuse me.
No, if you can notice that they will go to, they are going to demolish on 22nd. Like, what happened in CS record of right, our name has been recorded. in
Please,
the
Mr.
40
Ghosh.
decimal.
And I'm only available for this week. Wait, we'll get it.
On 22nd, they will
No, no.
demolish. Well, can I see the notice? That's why.
I understand, same petition for him. See the fate of this petition, then you mention.
Not only- Otherwise, we would know on 22nd hour.
I understand, I understand.
We are going to be.
Not
disclose it.
matter, the first sitting of your lordship, I had a talk with Mr. Menon. But I was told, today and tomorrow, it's personal difficulty, he is not available.
So I cannot take up the matter.
I understand, I cannot. What I am paying before your lordship, to move it by Friday, I'll take, the time I lack before your lordship,
I'll give the number.
I will not get the number. Your
Yes, you will
lordship,
be.
now the
Today,
lordship,
no, today is Tuesday.
keep inside the,
No, Tuesday, Friday you will be getting the, give the list date, list date.
I cannot serve it.
No.
Your lordship, when this side
Advance copy, sir.
situation,
No, advance
they will
copies.
not accept. They will not
Every
accept.
situation, Mr. You are a lawyer, you can meet every situation. I need give the number, that much I can tell you.
Lordship, this matter was mentioned by Mr. Mukherjee at the morning. Your Lordship directed to serve upon the other sides. We have served
Which Mukherjee?
Mr. Taposh Mukherjee.
No, I have not said anything. Service, then what happened?
I have served just to get tomorrow list. That's it.
Tomorrow list.
Otherwise, my property will be evicted. I shall be evicted on 21st August.
File it.
Plus,
File the writ petition. No leave granted. It will come in due.
it is pending. It is pending. That the two writs were taken by Honorable Justice Patrasarthi Sen. His Lordship was pleased to direct that two writ petition will be taken analogously. And after that matter was come in the list, but His Lordship is not.
I do not want to disturb my list. Today I cannot consider. Let me have.
Lordship, this notice has been served on 14th August. Only 14th August. That notice has been served.
Motion before your lordship urgent matter, because Lord 22nd, Lord, it is notice.
Otherwise, I say we shall be evicted from my property. That's
This is the number you have given. What is this? You are going to file. It is appearing in the list.
no. Writ petition is appearing in the code number 90.
Both the writ petitions are appearing.
Yes, Lordship.
Both the writ petitions,
Yes.
as you said, it has not appeared as per direction of the court.
No, Lordship. Lordship is not taking the matter. Actually, His Lordship is not.
বুঝতে পারেনি, sir?
Matter is running in the list, but
So take time. No, not possible to entertain every matter.
Lordship,
New question. Bro,
till
kindly one
22nd August, His Lordship will not sit.
খুব ভালো
No, no,
লাগছে।
22nd, it is my land. PW not the, under the Highways Act. Our representation have not been considered preferred appeal. Appeal without kindly the order passed from the appeal without consider. 40 decimals of land, 20 decimals were acquired by PWD. We are in possession of 20 decimals. It has been wrongly recorded as wrongful occupier. Our own land. And on that basis,
Why didn't you rectify the record?
Lord, we applied for that
But
it is
Mr.
our land.
Ghosh-
We survey the land, and if we are encroachers,
No.
It is our own
If
land.
maybe own land. Where have you approached the civil court?
Lord, it is recorded in our name in a wrongful, that wrongful.
Wrongful occupier. The
Yes.
wrongful occupier will be evicted.
And Lord, in some portion, our name has been recorded. You have transferred it. Transferee's name has been recorded. In spite of that, Lord, this is going to be done. Lord,
File it, give the number. I will try to accommodate.
Lord, we have filed, given notice.
Please give the number. I will try to. It is appearing. It is not possible for me.
What matter, your lordship? It will need few seconds by your lordship.
My unless Mr. Ghosh, you are being the senior member of the bar. I have come after coming to this determination of 1971 Act and 62 Act. What I found, this is the usual order. Everyone is coming for an order
there is an illegal encroachment on the government land or public land. There is nothing in the record to show that the land, which is the subject land, belong to the state. At least it is a duty of the state. What they are trying to settle the private scores. Everyone's house in front of them, there are encroachers. When I'm asking them, show me the record of rights that land belongs to the government, silent. And what is happening for a direction upon the authority to get involved in private disputes, like as you are saying, that this has been initiated from a direction of the court that consider the representation of the petitioner.
That has been done here. And Lord, the authority concerned has not made any whisper regarding our record of right and other things.
That whatever, it is you are recorded. I don't think that
I
you
am
are.
owner. I am not encroacher.
I am not going. But your record shows that you have been
Record shows I have been occupation.
occupation, wrongful
Lord,
occupation.
part wrongful and
Mr. Ghosh, don't invite me. I'm telling you.
I have shown, Lord, can you see? And
Don't invite me. I don't know. Give me the number. I will try to. I call the list. Call the list.
That same problem. And just now what your lordship observed, same victim, not only I, the difficulty comes in that, my lord, I challenged an order passed by this court directing consideration.
62 Act.
I'm
Two-
taking your lordship to the act, but
No,
before
don't
you-
take it.
No,
Just 5 minutes time allotted for
will
you.
come because
5 minutes time. Otherwise, I will release it. Where is the High Court order?
My lord, page 37. This is the order which attained finality. My appeal has been dismissed against this order.
What is this about? Why this is on can 1, can 2? What is
Look,
this?
what happened?
What was the initial order?
The
Make it
ins-
short, Mr. Gupta.
No, it will not take 1 minute. It will not take 1 or 2 minutes. It's only page 34 is the initial order. This initial order directs consideration by other authority, which
Where
has
is
been-
Mr. Dipendu Chatterjee?
My lord, he's in another court, my lord. I am
Ask him to come immediately.
My lord, kindly see a compilation of orders passed by the division bench, my lord. Kindly
I
see.
am giving all orders.
Oh, division
I
bench.
am
Let
giving.
him-
No.
Yes, my lord.
I am giving that order. Let him.
Where is the division bench order?
Let my learned friend place it. I am also handing
Page
over.
number 9. My lord,
Kindly have this order. Therefore, I was.
Page
my lord.
on 11
No, no, of course, I will.
Date of
place it.
delivery.
Kindly have a look to this order. The pace. I'm in 1 minute. I can.
My lord, already it has been demolished, my lord.
Already demolished.
No. Today is the
Already
date fixed.
almost demolished, my lord. I have
Can bolcho jo? Today is the date fixed, my lord.
the order.
Yesterday.
My lord,
I
kindly
replied
see
your
page
order.
number 19, my lord.
My lord, 1 minute I will take to clarify, my lord. Page 34 is the parent.
20, my lord.
By act second, I'm giving my lord that order also. Page 34 is the parent order which directed project engineer
This
to
is under
consider
64 Act. This was under the
section 10. No, boita,
Highways Act.
section 10 of 1964.
Oh, this is sorry. I'm taking that.
No.
Very well. Very well. This highways.
Section 10 of, my lord,
Forget about let me go through
Now-
the order.
kindly have a look to this order was recalled and modified that he is not the.
Please let me have the
Hello,
order of
I'm sorry.
division bench.
Your lordship will.
Where is the order dated 25th July?
25th July order ta do your side ke 25th July order ta the order ta
13th July, my lord. Page number 3, my lord. of the
30th July
No.
of the
Appeal is
compilation, my lord.
taken
Page number
considered subsequent to the order dated. What is 20? Appeal was directed.
July, my lord. Page number 3.
oh 20 July 25 হ্যাঁ July 25 এর এইটা এটা
Of the
ভুল
compilation.
লেখা আছে this would be 30 this is the order my lord এইটা this is yes এইটা in compilation your lordship will get it my lord by this the order was not interfered. So far, it is not interfering.
Wait. What happened to that report, 11th August report?
It was annexed in the report.
Page
Milord.
number
It was again taken on 12/8.
No, the
Compilation.
can one, the appeal is still pending.
No, disposed of.
This was top of them. I don't
All-
kindly see page number.
One,
19 of the-
one by one, huh? Show me the order dated 12 July,
Hmm.
passed on WPA 17782.
Page 37, which I was taking your lordship. Page 37 in the read petition. সবকটাতেই annex আছে। এই orderটা interfere হয়।
Mr. Chatterjee was the petitioner
Yes.
He
in
is
earlier case.
Private respondent number 8, my lord.
here,
They
but
are-
there,
There he was read petitioner.
then February 7, 2024. What was the order in February 7? Practically 12 July order is modification of the order dated February 7, 2024.
Is a form.
Where is that order, sir? February.
Page 34 is the first order.
February 7, 34, na?
February 7, yes, 34. But this do not stand now. This was recalled by the petitioner itself. It does not stand now. Page 37 stands now.
Representation consideration.
That was by
Ultimately-
project engineer.
Ultimately, representation
Yes,
consideration of the private respondent alleging unauthorized occupation
Yes.
or encroachment in the highway.
According to them, there was
Encroachment in the highway, that was the
According-
allegation. The representation against that or this order, the order dated 12 July. Against order dated 12 July, appeal was preferred.
yes,
The
475.
appeal court has affirmed the order,
Yes.
and by the order, which order it has been affirmed?
Now, Milord, 20, kindly look to July 30 to 25 order.
Page.
Your lordship have been given the bunch. If your lordship wants, Milord, I can give this.
Page 3.
July 30, 2025 is the order by which it was not interfered with.
Then the report was called for.
Now, Milord,
Then
I am
what
coming.
happened to August 11?
Milord, I am coming. Kindly have a look to paragraph 20.
Paragraph, I'll follow.
Yes.
August 11.
Thereafter, on August 11, to satisfy the division bench, they produced a communication that in view of the report, they are going to demolish it. Such communication was recorded in the next order by which the appeal was disposed of. 12/8/25.
Kindly see the page.
Kindly have a look to
Page.
14. 1/4.
that is order dated 12/8/25 by which the appeal was disposed of, recording that a communication is made available before the court that the authority will take action in accordance with law, and 12th is the date fixed. This I got, my lord, aware of in my appeal while it was on the date of disposal, and the court recorded that the writ petition is pending.
It was also recorded that since there
11th August, communication was made that they will take action as desired.
is it on today.
And today it has been
Therefore,
partly
urgency
demolished.
all
It has
clear.
already been demolished, partly demolished according to you. Very well. Now the challenge is now, which order?
Now, my lord, the challenge is the parent order passed by the project director 6 March 25, by which representation was directed to be considered. Kindly look to page 41 of the writ petition.
Yes, 6 March order.
Yes, kindly look to last paragraph.
6th March order was in compliance with the direction of the learned single judge.
Yes,
Pass.
grateful to Lordship. Kindly come to this order for against which this writ is filed. Today, no private respondent. Did you?
I am not come to the last paragraph.
Yes, however, as per order of Honorable Court dated 7/2/24, read with 12/7/24, the authority has to pass an order within 6 weeks from date of communication. The order was communicated to project director by Advocate Divyendu Chatterjee, by letter dated such and such, received on such and such. Now, on the basis of report submitted by BLLRO, Chagda, through his memo number 10/125, it can be concluded that plot number such and such is in front of plot number 6665 Moja as per record. Total area of plot number 1351475 of noted Moja 0.54 acre of land is recorded in favor of Government of West Bengal in Khotian 1 and recorded as Nayanjali. Now, Nayanjali, thereafter, it comes to the BLLRO is also requested. The BLLRO Chagda also recorded that there are some shops in the said plot, but the owner shop did not produce any document relating to possession. Thus, it appears that the shops occupied in plot number such and such are considered.
Yes. Anything?
Now, my lord, I come to the order of the project director itself. These are the two orders passed by project director which nullifies this order 6/3/25 itself. দুটো অর্ডারটা দাও, একটা 14/11/25 আর একটা 25। These are the two, হ্যাঁ আমাকে একটু কথা দাও। These are the two orders prior to 6/3/25 passed by project director. 14/11টা দাও আর তারপর 5/12টা দাও। Kindly have a look to these two orders prior to 6/3/25. The project director, considering the stand of the private respondent recorded, my lord, I am reading from 14/11/24, taking into account the representation of the parties present, BLLRO Chagda, Nodia is once again directed to demarcate the extent of right government land at that location. My lord, I put emphasis, my lord, with due notice to all concerned and submit a detailed report with sketch map on Moja by 4/12/24. This, my lord, directs that BLLRO will give me a notice, conduct an inquiry, which was never done. 6/3/25 order.
Then
My lord, I am coming. Kindly have a look to 5/12/24. It also records admission on the part of BLLRO that this was not done. Kindly, my lord, take trouble to 5/12/24. Taking into account, the revenue officer stated, did your lordship, my lord, get it? First, second, third, fourth, fifth or sixth paragraph. Revenue officer stated that demarcation is yet to be carried out due to non-availability of surveyors with their office.
Now,
and
after December up to March, this was not done.
no, my lord, my specific case is that this was not done. Let them file an affidavit. I will.
Sorry.
I'm sorry, my lord. I'm sorry.
Who is in the state? This is 11. I'm hearing what is 11. 9. Who is 9?
9, 10, 11.
9. Who is in 9?
9, 10, 11.
This has not been carried out. Demarcation not carried out.
I have no such information.
Why you have appeared? Why you have appeared then?
My lord, in the so far my knowledge goes, all the matters have been fixed for hearing by the jurisdictional judge, that is Justice Parthasarthi,
on 2nd September. But so was the all report was submitted on 2nd September.
After this,
What is the
কি
case of
বলছেন?
whether the land, the
Case of the petitioner, I will deal with that. I want to know an information from you. That this is admittedly under comprised in
August 11.
after the petition order.
give me certain, you say that this was done.
August 11 এ বলেছে আজকে ভাঙবো।
5th December 24, revenue officer is saying that however the record such and such order was communicated to project the such and such on such. Oh, acha. Which BLRO?
Chagda. And in the order, page 41, the order which has been passed is placing reliance on 10/125. When the subsequent order says that he has not carried out.
Forget about this. What has been recorded subsequently on 10 January 25, BLRO Chagda through email has submitted a field inquiry
Yes.
and demarcation report in the matter of such and such. How do you can overcome this?
The same BLLRO before project director on subsequent date admitted he has not done. And admittedly,
When this was done on 14/11 and 14, and this is on 10 January 25.
yes, below 14/11, this was passed ex party. Therefore, this report,
I have heard you. Asun.
this report was, they never conducted any inquiry. The order was passed ex party. The report was never, he went to comply with the order and direction
Would you
passed.
like to take a chance before the regular bench?
Milord, there is no difficulty on my part, Milord, in going.
Sorry,
I have
no
to
interim
approach.
order.
Milord, this is because August 11, they have given this notice that today they will demolish. On that date, I was not having this cause of action. So they want Milord to demolish it in the,
The affidavit of service. Give me the affidavit of service.
Milord, thrice I have served to all respondents.
Affidavit of
And these are the affidavits so that this type of pleas are not taken before the court.
affidavit of-
Kindly record that 3 times I have served.
affidavit of service filed on behalf of the petitioner be kept with the record.
An earlier writ petition was dismissed by my Lord Justice Mantha.
Petitioners. The order as a
And what, Milord, I'm sorry to disturb your lordship. The next petitioner is a dead person. I'm sorry to disturb your lordship. In the next one, Munmun is not a party. I'm sorry to disturb your lordship. 1 minute, I would like to check before your lordship.
Next matter, I have not gone. Let me
I am sorry.
let me dismiss it, then I will go to the next one. The private respondent numbers 8 and 9 had filed a writ petition in WPA 17782 of 2018 alleging encroachment in where is the earlier order in the compilation?
Earlier order, I have annexed in the writ petition, page
No,
37.
the original order. The
Original order is in the earlier, your lordship will find it in 34. But that do not stand in
No, page 34 is not the original order.
7 to 24, that is the original order, which was modified by page 37. That was only change of authority. The page 32 is the earlier writ petition which was dismissed.
Yes.
On merit upon exchange of affidavits.
See the original order passed in WPA 17782. This 34 is a modification of the
No, it's the parent order. It's the parent order. It's not modified. 37, 12th 7th order is modification order. 12th July 24 is the modification order. And 7th February is the parent order. Huh? The other- My lord, this is the parent.
alleging encroachment in the PWD road Litigation lead number এত alleging encroachment PWD by the petitioners. They said it petition. A direction was made on February 7, 2024 upon the concerned concerned respondent authorities, upon the Executive Engineer Nodia Highway Division Highway Division of PWD to decide to consider the said the pending representation of the petitioner with petitioner in accordance and to pass a reasoned order thereon. In compliance with the said direction, the project director within bracket 2 West Bengal Highway Development Corporation Limited, the respondent number such and such has passed the impugned order dated March 6, 2025. Mr. Mohendra Gupta, learned advocate for the petitioner, submits that the project direct that no notice that though the respondent number 6 is obliged to give notice to the petitioners, but no such notice was given. No such notice was given. Besides, the revenue officer was obliged to demarcate the land on which in respect of which the allegation of encroachment is there. The same demarcation is also has not been made. It appears from the Mr. Mahata learned advocate. You are appearing for the state.
Item number 10.
You are for the 9 in 9. Submits that the order of the landed single judge has been affirmed in appeal, and the appeal court has directed to had directed to submit a report on August 12, 11, 2025 with the observation that there is no stay of the order of removal of unauthorized construction. Therefore, steps taken with regard to implementation of the order for removal of unauthorized construction be reported to the said court. Such report was filed before the Honorable Division Bench. Stop. And in view of the order of the Honorable Division Bench, there is no scope to interfere with the order impugned. Hard learned counsel for the parties peruse the materials of record. It appears that in the order impugned, it has been recorded that on January 10, 2025, the concerned BLLRO through email has submitted the field inquiry and demarcation report by memo number, এখানে memo আছে 41 dated January 10, 2025. Upon consideration of the said report. The respondent number 6 has filed, has passed the order of demolition with the following, with the following findings. এটাকে তুলে দেবেন পুরোটা, ঠিক আছে? In view of this same, there is no scope to interfere with the order impugn. WPA such and such is dismissed. What is the next one?
Milord, if your lordship may once record it, Milord, that it was not done, giving us notice.
I have recorded.
Milord, let them.
No,
file
that
it.
is recorded also. 10 January 25.
Even if your lordship.
Matter is over. Go before the appeal court.
Page, the next one is.
Now the next one.
Next one is, the order has been passed against a dead person.
Who is the
They
dead
did
person?
not ascertain that whether he is living or not.
Who is the
So I
dead?
have to come from heaven to have this order
Who
implemented.
who is the dead person?
Makhon Lal Sarkar, this is respondent number 10. Kindly have a look to
Respondent number?
10 in earlier writ petition. Here I am petition.
And the order has been passed against
Against
Makhon Lal.
dead person, that your lordship will get it at page 44. Page 44, your lordship will find to Makhon Sarkar. He is the dead person. Makhon Sarkar. died-
Where I'll be getting it?
Page 44.
44.
44. In all orders, your lordship will get it, starting from page 42.
Makhon Sarkar.
Yes, page 42, he is respondent number 10. Page 44, in 5, Makhon Sarkar.
When he has died?
In 2010. Page 31 is the death
No,
certificate.
in 2010, you had participated, you never informed the
I
authority.
have never participated.
Acha.
And they say
It is what
that I have participated.
Tell-
So from heaven I will be coming, my lord.
The matter is going before the division bench, single bench.
No one has pointed out.
No one has noted. My
Makhon was a party before the division bench.
lord, in the.
No. Makhon was not an appellant. He was a private respondent in earlier writ petition.
Who are you? The is espousing the cause of Makhon?
His heir, my lord.
Who is his heir?
Daughter, his daughter.
Is before me. This Munmun Ghosh is the daughter of.
Makhon Lal Sarkar. Makhon was a
What is
private
his
respondent.
structure? What is his structure?
My lord, he is carrying a business, beauty parlor shop for last 25, 30 years. But admittedly, his father died in 2010.
Remove all of
Dead
them.
man was made party.
Arrest this person.
And recording is made that he has not appeared.
Arrest this petitioner.
That now this person is dead. This is being quoted or.
No, can for thou. Can for it was placed before the authority that he is dead. He is recording that he has not appeared. How he will appear if he is, they cannot serve a notice also. Milord 10.
Reduce your tension.
I'm sorry.
I will keep the beauty parlor for your visit. Please reduce your
I'm
tension.
sorry. Milord.
So far,
10-1 notice ta da. 10-1.
no, remove the entire order,
Boita da.
except the petitioner for the time being. For the time being, give this, yes, I'll give this petitioner an opportunity.
It's not binding
There are-
at all. It's nullity on the face of it.
I'm not taking this matter now.
I'm sorry.
You take steps, bring the information, whether it is already there or not. Nothing can be done now. If it is already demolished, very well, come tomorrow, inform this court, come tomorrow, inform the, but if it is, even it is demolished, the portion which was occupying, let you don't touch it now for the time being. Then give her a notice, make her understand that her occupation there is unauthorized, then do it.
10, 1, 2, 3, 4,
Tomorrow-
they should comply and do that.
10, item number 11,
Same order,
Item number 11, in this case, there is no date.
same order,
It is similar to 9. Similar
same
to
order.
9.
What happened? Therefore, this is the same impugn order. This cannot be sustained.
This case, there is no date. It is, my lord, same
Same order.
item number. My lord, may I have a copy what they
Yes, supply him a
so
copy.
that I can understand what they have to.
Double 13
9 and 11 are dismissed.
and 9 and 11.
One or
Only one, that is what is called Moon Bishas, not today, you take instruction.
I am just now taking information.
Dismissed. 12,
wants, my lord, instead of dismissals, he wants disposal. It will be helping me. Let there be no order, but kindly considering
Mr.
submission.
Gupta, you have become pretty senior now.
Sorry, I'm sorry. I'm sorry. Grateful.
I am for the petition in this matter. Item number 3.
Demolition.
On 23rd of July 2020.
Demolition.
Demolition, Lordship. But, Lordship.
Don't move it before me.
Kindly, Lordship. Kindly,
That is the order impugned.
Under 10.3 of the West Bengal.
Why is the order impugned?
At page 25, Lordship. Kindly, Lordship, consider page 25. Once for a moment, Lordship. Page 25, Lordship may please to consider the numeric number 4. Sukanta Kumar Goswami, then Lordship, Sri Nirmal Ben, private respondent number 8, therein, one writ petition was filed before this honorable court by the private respondent herein, and for that reason, the one writ petition, I have been forced to sell my, kindly, Lordship, consider, was found absent again and the
Why are you inviting dismissal? Go before the regular bench.
kindly,
Matter is
Lordship,
placed
kindly,
before
Lordship, consider.
I am appealing
Kindly.
on 8. Copy has not been sub to me.
Oh,
I am the
oh,
private.
Sub it, place it before the, there is no urgency, matter is
Yes,
placed
Lord,
before the regular bench.
Demolition already.
Go
Kindly,
before
Lordship,
this.
consider.
Don't invite.
I was absent.
Sub.
I was absent, but the
Serve it.
I was
No.
admitted.
Serve him.
Yes, I said, kindly Lordship, take it, considers for 2 minutes, Lordship. 2 minutes. I am taking the valuable time of 2 minutes only, Lordship.
Valuable time.
The Lordship is so kind enough. Lordship is so kind enough. Lordship, please to consider only for the one line, just for one line. Kindly Lordship, just was found absent. That is the record in.
You are present now?
I am present, but
Very well.
the petitioner was the unfortunate petitioner before your Lordship. At the time of hearing of the writ petition, he was absent. At the time of hearing of the 10.3 highway, West Bengal Highway Act, the order was passed, he was absent. But it is recorded in the order, he was present. He has confessed that the.
Now tell me what is your defense to be there?
That is the Lordship may please to consider the photographs and also the one of the.
Let it take this photograph. Keep a good
That should be
frame.
present in the wall. And the
Yes.
demolition will be done.
Go before the regular bench.
Lordship,
Next one.
7 days stay. Lordship, I'm only for the 7 days.
That you are inviting.
My hearing could be given.
No, sorry,
Opportunity.
I am giving you the hearing. The photograph is there. I'm seeing the photograph. Go before the. I don't feel good in rejecting today.
Chance to submit my document.
Go before that. 13, eh?
There is the appeal provision also.
Sorry,
For the same days.
sorry.
Lordship.
13.
7 days. That within 7
আরে
days.
ডাকো না, দাও না ফাইলটা। Go before the regular bench.
This was before the regular bench. Order was passed on 23rd of July. Matter filed on 1st of August. I have mentioned the matter before the regular bench. Regular bench, please to direct that if the building will be demolished, it will be restored. How can it be restored? I am asking myself, Lordship. But Lordship, please to consider, Lordship.
That is a good idea.
Before your Lordship,
Give it,
Lordship,
give it, give
Lordship, for the 7 days stay to be kept.
Stop now. Who is this one?
Grateful, Lordship.
একটা রেগুলার বেঞ্চে পাঠিয়ে দাও। এতগুলো ডিসমিস হবে What is this?
My lord, this matter relating to my lord MSc nursing, my lord, they already 8 months the class hold, my lord. University within the stipulated seat, within the stipulated time frame, they admit it, my lord, and they took admission, my lord. Already they took loan from the bank, my lord, or University of Health Sciences. They hold our registration, my lord. That's the case in nutshell, my lord. But
We don't have the qualification to be, may not have the qualification.
my lord, that's why when I place my case, my lord, first. But all the petitioner here in my lord, they are pursuing MSc nursing.
MSc nursing.
nursing, yes, my lord. MSc nursing, my lord, there is a admission examination.
Who is the authority to register?
West Bengal University of Health
Who is
Sciences.
for the West Bengal University for Health Science?
And I am for this.
What is the difficulty?
But they have yet not got the allotment letter and got the admission in the college.
Yes.
After.
Which is the college?
Throughout
The college.
All right, in 21-22, I'm for the International Institute of Nursing, one of the college I am appealing.
Oh, you are international figure.
Then the name is that. The name is international.
Sir, there are no allotment, mean how
One
can
of
you get them
Situation
admitted?
is otherwise. My lord, there was no stray or mop-up round for private colleges. 3 counseling, mop-up only for, my lord, the government colleges. Now, for last 4 session, it is the procedure if left vacancies are there. Now, from
So earlier notification was
Now,
there.
from the
These year no such notification.
now, from the rank, the person should
I have
rank
already decided the issue.
No,
Here
my lord,
also
that
keep-
is not, but I believe, my lord, that is not the issue here. My lord, what
No.
happened? My lord, I just place my case first. Thereafter, my lord,
No allotment. Let me, you are saying you have got admission in this international college.
and that is
there are
within-
several college, my lord. Through
So how can you map?
yes, because through but university is the same.
Maybe,
Yes.
but what are the
Yes,
colleges?
but at the same course. My lord, kindly we participate. Kindly, what is my homogeneity? I place my case, my lord.
No,
But the homogeneity is that, my lord, we participate the admission test, my lord. Being an eligible candidate, we participate therein. Thereafter, we
How many
got the
colleges
rank.
are involved?
All the colleges, my lord. And in this year,
college
my
at
lord,
R.N. Tagore Hospital.
yes, C.K. Birla, R.N. Tagore, IINS, all the private nursing colleges, my lord. All the private nursing colleges who conducted that course under West Bengal University of Health Sciences. What happened? I placed the case because in this year, 2 other deemed private university, similarly situated candidate, they already got the registration by the same
Where are the
information
colleges?
bulletin. That is SNU, Sister Nivedita University, and another one is Technical University. These 2 are the
Now let us see how many colleges are before me. Only you.
I am for one.
and I was
Other
informed
colleges?
in other college, Mr. Basu will appear. Saptangshu Basu. Because
He requires nursing.
yes.
Inform him.
Affidavit of service as well as court fees.
Hey, inform him.
Yes. And deficit court fees, my lord.
Inform.
Yes.
These are informed all other nursing councils.
Yes, my lord.
All other nursing colleges. Mr. Basu is appearing for all other nursing colleges.
Hopefully,
Inform,
not.
na.
I just told my junior.
Then how can you get take the admission of them if they are not? What is the procedure for admission?
Procedure for admission for subject to correction with
Let the university say.
university.
What is the procedure for admission in the colleges?
West Bengal Joint Entrance Board conduct examination.
That was they participated.
Participate.
Then what happened?
Result was published. Rank was prepared.
And you have sent them to the colleges
No,
according to the rank.
They have no role.
that is we at that part we don't have role.
Then
That WBA MCC and DME, particularly Director of Medical Education, they have conducted counseling procedure.
Acha.
And
Who is appearing for that authority?
with the
State.
association of
I
Indian,
appear for the state.
West Bengal State Nursing Council.
And nursing council, I'm not appearing. I'm appearing for the state, my lord. I am
So who is for the nursing council?
Maybe
Nursing
contacting
council, normally Mr.
Abish Sarkar. So this was counseling was done there.
Yes.
counseling was done.
And we
They have
participate.
participated in the counseling procedure, and at the time of counseling procedures, to each and every student got the allotment letter through email. And these students did not get any allotment letter because
Who had issued that allotment letter?
the counseling authority.
Counseling authority. So there is a joint effort on this exercise, state and that.
Nursing counseling.
Yes, yes,
West Bengal Joint Entrance Board.
yes.
Counseling was conducted by, who is representing that Joint Entrance Board?
Well, that is not, because that is not a subject matter of dispute.
But
If want, I can start, but that is not.
what is the subject matter? Subject matter is that they are saying that you are unable to show the allotment. Show the allotment, get the registration.
This is not a case of allotment letter.
He is saying, produce allotment.
Which provision of law they got that power? Malad, kindly,
how you
Malad,
can?
they have to say it. I have admission letter, Malad, admission slip. What, Malad, my case is that
Admission
one.
slip means?
Admission slip of the college. Because what is the case?
How you reach to the college? At the time of counseling, you have choose. You have made a choice.
Yes.
You have made a choice.
I just give an example, Malad. I just.
You have made a choice. You got a college, right?
Not got the college at the time of counseling. Why? Because of that, well, suppose there are 20 college. I just give an example. There are 20 college. Suppose including R.N. Tagore and C.K. Birla. Each college, suppose 100 seats are there. There are 3 rounds of counseling. So each and every college, I have a claim being a student on that particular 100 seats. But in the seat matrix, they're not shown, my lord, or might be, I don't know. But at that point of time, my lord, I not got that admission. Earlier year also, since 2020, my lord,
So
it is a practice as well as this year also, other 2 deemed university. One is SNU, another one is Techno University. In the similar way, the similar fashion.
Earlier notification was there.
I am not saying the earlier year, this year, my lord. SNU and Techno, this year it's happened. A specific amendment in my writ petition. In this year, my lord, they divide it, they bifurcate it between college and university. They can't do it.
Very well.
Why? Because of that, my lord.
I thought your problem is with the registration.
Yes, that's the problem.
Then
That's the problem.
if that be the problem, what they are saying that you don't have the allotment later.
So I have to show
Right.
that allotment letter.
That allotment later, why they don't have the allotment later? What was the reason for not having the allotment? Well, the counseling they have done.
Authority, maybe their merit is not reached as per the counseling procedure. Maybe because we are not a counseling authority.
And may I just intervene, Malad? The report that I have received, Malad, from the report it appears that, Malad, for this year, the period, Malad, the last date of counseling and the last date of allotment, the admission, there was only a 1-day gap. For which, Malad, like the years, Malad, where the circulars were published, allowing the students to go to the private institutions, this was not done. But in the interactum, these students somehow took admissions.
Achha.
For that, the allotment letter of some computer generated allotment paper was not generated in their favor. And the issue for which the petitioners are today here before your lordship.
Achha. Well, this allotment letter was not issued for the effect of this allotment letter that earlier years after this is situation after counseling. A situation after counseling.
Admission.
Prior to admission means?
After the counseling, the admission will be affected. So, the gap between the counseling and the admission, it was only a 1-day gap. So years, I believe there was some period between these 2 activities, that is counseling and the admission.
Now, what is the difficulty in giving them admission and to?
No difficulty. No difficulty. West Bengal University of Health Science, difficulty. Our report says so.
There is no difficulty.
Everywhere their admission procedure is not fair.
That is what is the unfairness.
If state affirm that their admission is fair, we can give them registration.
State is to affirm their admission is fair.
Because allotment letter is a clear picture. They have a fair process of admission. Because there is sometimes a backdoor admission.
Out of page 361, out of page 361, the institute described the entire situation. What happened here? Because the TR trainee reserve seats that was allotted in respect of all institutions, trainee reserve.
No,
Now,
training reserve for the government hospitals.
For the government employee.
Even my lord, in the private institution, trainee reserve, that is there. Now, in this year, what particularly happened, there was a delay in publishing the tier list. And ultimately, my lord, they couldn't give that no objection. Now, our vacancies, that's remain vacant. And my lord, due to their fault,
You have directly, the students directly came to you.
yes, who are within the, my lord, qualified rank, who are qualified in that particular examination.
I have a claim because we have meritorious candidate, we participate and we
Now,
have the
still
rank.
there was no
In
stay.
accordance with rank.
Another thing is, well, it has to be guided by the INC norms. If it is the INC norms, they are eligible to be admitted. Now, problem cropped up in the last few years, same procedure adopted. And after
What is the same procedure?
after the mop-up round, on the mop-up round, all eligible candidates are ANC and in the rank, not who are not in the rank, all admitted, and subsequently it was registered. Only for the first time this year, when the same procedure adopted by the institutions like our institution, then they are saying, no, now this year it cannot be given. This was followed for quite some years.
In addition to Mr. Basu, this year is also followed in case of SNU and Techno University. This only this government university, they just uphold it. I don't know what is the reason. They just hold it. What is the reason?
No. Which of the two universities this has been done?
Techno University and
The private.
but the rule is the same. The information bulletin is the same. The guiding statute is also the same. But
Therefore, why they have chosen for these two? This is your question. Why they have chosen these two?
Yes, if they are permissible.
Why this? You have allowed the two institute to take admission and registration?
In ground, my lord, there cannot be discrimination because only they are deemed university. That's all. But they are also university.
Same guided by the
same course.
Guided by the same statute, guided by the same information bulletin, guided by and they took admission from the same pool. We are the unlucky one. We choose that within this university. We are the unlucky person. We took loan from the bank, and now they are says we will hold it.
আমার ইনস্ট্রাকশন এই তো
যদি বলে as per merit,
don't have any allotment letter. This is the main reason to restrain from their giving registration. And this is the norms that are in medical science and
your problem is that registration is lacking now.
They're not giving the registration.
So that
Even we fill up the registration form, we already gave the registration fee.
Come to your
Yes. The registration.
continuing with this study.
We are continuing. Last 8 months, my lord, we took admission. Classes is going on last 8 months, and we are paying the EMI.
What EMI?
Yes,
Taking loan.
Student credit loan, and I also annex herein.
Come to your fair.
Yes, sir. They just uphold it. Registration process.
Who is preventing you to pursue it?
West Bengal University of Health Sciences.
Registration is not given.
Not dead.
Where is your prayer for registration?
Kindly see, step to complete the registration process. Registration process is not completed.
Where?
Page number 280. B.
Prayer B, my lord, at page 41.
Prayer B.
page 41.
Page 41. My lord, this kindly turn page number 220. Where I am
Complete the registration process, right? This
yes,
is your.
Yes. Kindly see page number 220. I fill up the registration form as well as college verification is also done. The third step, which is on the part of the West Bengal University of Health,
209.
220, page number 220. They just hold it. And before that, my lord, we submitted everything. Even they took the fees also from me.
We have not taken. That is, the portal is open. You can pay.
Obviously, if you get it and you say that we are not taken. What is the type of submission?
Which space is?
Page number 220, kindly the third step. The third step is a hold. Kindly see the word university verification hold. Upload large signature.
No, basic higher secondary qualification.
Everything
address,
is there.
Qualification information, there you are stuck or qualifying
No,
examination.
my lord.
No,
College verification
on
is
rank.
completed. We are rank holder. We participate even in
At
council.
what stage you are stuck in this page
Page number
220?
220, third step, my lord, the third step for registration form fill up. After taking admission in the college, my
Page
lord.
220, this page.
Yes, my lord.
Which one you are showing?
Yes, my lord. No. Madrasa MSc.
Yes, my lord, page 220. 220, kindly come to the top.
Top. Kindly.
Top, my lord, there is a line 1, 2, and 3. Your lordship got it?
Yes,
at the top.
registration submitted.
Submitted. Then second is my lord, college verification
completed.
completed. Now third is university verification.
Hold.
That is the problem.
This situation.
Why it is in hold?
That is, we have a restricted, they must be infringe the merit list.
So
That's why they don't have get any allotment letter.
So the
This
one.
is the main reason. There is a lack of document. That is that the student don't have any allotment letter.
Who will issue that?
Counseling authority.
Who is for the joint entrance board?
Counseling authority.
all are on merit list. Take it from me.
Yes.
All candidates
you
are
annexed
on
it.
merit
You
list.
don't have that much experience about nurses. You may have about the doctors.
But my lord, nurses are.
You require, but I God forbid not now. Just wait for some days.
It's a blessing.
Who is Mr. Amitabh Chaudhary? He is a West Bengal Joint Entrance Board is a party here.
No, my lord, not network. My lord, kindly turn page number.
Well, West Bengal Joint Entrance Board is a party here.
No, my lord, no,
So add him, serve him notice. Let us understand what between the university and
yes.
regarding if you have any doubt about the competence, qualification of the
Yes.
petitioners,
I
let it be
will
verified.
satisfy here and now. Kindly turn.
No, you don't satisfy.
My lord, kindly turn page number
let
75
them-
for us. For once. Page number 75 for once. The first petitioner, her rank 713.
Maybe let it be independently
Yes,
joint
madam.
entrance board verify it. Is there any
Yes,
doubt?
any type of verification. Any type of verification. We want to face it.
And last, I repeat, well, last 3 years, this is going on.
The process is going.
I want to face any type of verification. Any type of verification.
That's a self-financed college.
Let me
Yes,
let
yes.
myself satisfied
Yes,
when
yes,
the
yes.
allegation is coming from the university.
Yes, my lord can take a test case and my lord can be satisfied. It's a test case. One candidate can test whether she is under the category or not can test.
I just
That
want
he has shown that.
my page number, yes, madam. Page number 75, at proper page number 121, the Triporna Banerjee, the first candidate. Each and everyone's merited.
Why are you
Page number
putting
75.
problem for them?
Page number 75, Triporna Banerjee, her rank, page number 713, her registration form, page number 121. Got it, my lord? Everyone.
Deposit code fees,
Yes, my lord. Already.
affidavit of service and ওই যেটা লেখো আর কি। চালান evidence এগুলো
Just
kept
one
in
thing.
the record। এবার লেখো
তারিখের মধ্যে আমাদের research করতে হবে।
the
করে দিন, এক্ষুনি দিন।
commissioner are claiming to be qualified for MSc nursing course. They have already taken admission, na?
Yes, 8 months class.
Imparting education, taking classes.
8
Last
months.
1 year.
8
9 months.
My lord,
They
as a state university, director of medical education should be necessary party. Because all the education system of the
State is the party.
State is appearing, my lord.
State is appearing, state is party, state will take care of.
Director of medical education. No, director of medical
He is
education
another
is
state.
required to be added as separately a party.
No.
Party. Kali give grant leave to add.
The fellow.
DHS, DME to state.
And they are pursuing these 8 courses in different colleges, nursing colleges. The petitioners are alleging that West Bengal University of Health Sciences are refusing to register them in the courses they are pursuing. In respect of the courses they are pursuing. Learned advocate for the respondent of 5 hearing. University of West Bengal University of Health Sciences. The respondent of 5 hearing. Learned advocate for the respondent number 5 submits that they are the petitioners since are unable to produce the what is that allotment letter? Allotment letter.
Seat allotment letter.
The
We have admission.
respondent number 5 is unable to register them. So, petitioners are claiming to be duly qualified in the what is the selection process you say?
Page number 47, my lord, kindly take.
Selection of these nurses in what is that?
MSc nursing course.
No, what is
That
the
is-
qualifying exam?
No. JE
JE MScN. Kindly turn page number 47.
Master of Science in Nursing.
Oh, yes, yes.
Kindly turn page number 47.
In such and such examination.
MSc
And
and JE PBN also.
Since
When
there is a doubt expressed regarding their qualification, regarding their eligibility to pursue this said course, the West Bengal Joint Entrance Board, na?
Yes.
And the Director of Medical Education, presence of Director of Medical Education Board, Government of West Bengal, are required to be added as the respondents.
West Bengal Joint Entrance Board.
Leave therefore granted to the learned advocate for the petitioners to add the said two authorities as party respondents to the writ petition. Copy of the writ petition be served upon the joint entrance.
এরাই জানাবে ডিএমির হয়ে এরাই জানাবে
No, West Bengal Joint Entrance Board, na? West Bengal Joint Entrance Board. Mr. Singh,
all are the part of the
Joint Entrance Examination Board. So there is a separate law here, and Mr. Sen, since he is appearing London, AAG, AAG. Since he is appearing on behalf of the state, no further notice be added, and we need be served upon the Director of General Health Sciences. You bring Mr. Chaudhary
Yes, yes.
and so that
Yes.
they can resolve the issue in
Yes,
between.
yes, yes. That is a nothing. I believe before
AAG, I know. Congratulations for
Don't
the
give
new.
cognizance. No treat up till now.
no party.
I am behind him.
Till that
You
no
know
party.
that. Double AG, not single.
That I'm saying. Double AG. We should get something.
9th September and 10th September.
My lord, kindly interim order is necessary in this meanwhile because of that. Not why.
Not to
Because
discontinue.
that within 31st, my lord, they ought to submit their research proposal.
Before the bench, which will be.
Research proposal, my lord. My lord, then my lord, they ought to extend, the university ought to extend that time because research paper proposal ought to submit it within the
If you
31st
cannot
August.
wait-
That's the reason of
Cannot
urgency.
wait 10th September, then you
If
have to.
university says I will take it after that, have no problem.
Pilot is there, no problem. It
10th
will be extended.
September.
If my lord take care of that, my lord, I have no.
Till this pending. Madam is taking care of everything,
Yes, obvious.
including Bhola Babu.
Oh, that Mr. Chatterjee will provide you. Write it on a piece
Namta.
of paper.
Yes, for the The next one is
Sir,
my lord.
give precedent in these matters. Three matters are there.
My lord, this items 13, 14 and 15. And
How
item
much-
number 14 about this course names is MSc NPCC. Nursing practitioner in critical care. That is
Write it down.
I will.
Course name is different. but
Course name.
yes,
Course
same.
name is.
But write it down the
Yes,
course
yes,
name
yes.
in full, in
Yes,
full
yes.
and in
And the
short.
third one name is post basic nursing. I will write it.
This is also master's degree, post basic.
Yes, yes, all are master degree. After GNM, post basic nursing. After BSc, that is MSc NPCC, because NPCC is critical care. They will take critical care. And
You are representing for all of them,
I am representing the college.
all the colleges.
No, my lord knows. My daughter is there. I have to represent.
West Bengal Nursing Council has been not at a party.
I will do it. But that is they have no role.
These body are taking all this care.
No, you don't have he has no role.
Director of medical education.
Yes, sir.
Director of Medical Education,
Give
you
proper party.
and West
Give
Bengal
proper
Joint Entrance
Name the
Board.
proper party.
These are the parties, they will resolve it,
Yes.
right?
Yes, yes. West Bengal Nursing
এরকম
যদি
করে
কোনো এক-
খালি পোস্ট গুলো আলাদা। হ্যাঁ, ওটা ও ইয়ে দিতে হয় শামীম দেবেন আর চ্যাটার্জি দেবেন।
MSc critical care.
Pursuing their-
13-15 হ্যাঁ?
MSc.
And in other two writ petitions, same parties will be added.
Yes, yes, yes.
Same parties.
এটার
একটা করে দেখো আমাকে।
আর একটা পোস্ট বেসিক নার্সিং পোস্ট বেসিক একটা 15টা দাও
So what about that? My prayer.
It is a reasonable.
Malad, in 3 cases, Malad, individual service as
I
well.
don't think, Mr. Same, it will be time barred.
But the Malad, the student, Malad, they are agree. They are
I have
agree.
told him I cannot say in open court.
Malad, the student and they are agree because all the student not get entry. Malad.
Medical
That's why Malad,
Reference দরকার নেই।
আমরা জয় সাহেবকে দেখবো না।
Oh, acha. Students must continue.
Yes, yes, yes.
They
Malad,
should,
they are meritorious.
They are not
According
saying
to the merit, Malad, they got it. Otherwise, I will inquire in this matter. Thereafter, I took this matter, Malad. Yeah, obviously. Since 2020.
Why there is addition of their tension? There should not be increase in their tension. They are pursuing it.
That Malad, others in the same college, their student also, they submitted their research paper, but they are
Till ask them wait till
some
10th.
priority. I asked for some priority.
Till 10th, it will be there.
Yes, I am extremely grateful. If the court is there, nothing, I have nothing to worry. খবর দিয়ে দিচ্ছি তো আমি নামগুলো দিয়ে দিচ্ছি ঠিক আছে আমি গোপায় শেয়ার করবো গ্রেটফুল ম্যাম এক্সট্রিমলি এখন পাঠিয়ে এখনই দিয়ে দিচ্ছি এই নামগুলো দিয়ে দিচ্ছি
16. Yes, Mr. Acharya, what is this?
Come before your lordship, under the unauthorized occupant act.
Huh?
West Bengal unauthorized occupation act. Now, my lord, kindly have a
62
look.
or
page-
64?
My lord, kindly have a look page.
Civil suit pending.
Yes, yes.
Page 40.
Civil suit pending, injunction pending.
Injunction in our favor, in the.
Counter blast of the civil suit, nothing else.
Just which is the public land?
My lord, it is land belongs to my lord irrigation department. My lord, I am,
Government land, plot number 86,
yes.
jail number such and such, Mouja, Bolarampur. Show me that it belongs to irrigation department.
My lord, that I am stated so.
No, statement will not do. Private dispute is cannot be fixed in this way.
Page,
Show me the record of rights.
page,
Dark number 836.
page 39, your lordship will kindly consider.
What is this?
Name of the private respondent.
No, I'm not going to. I want to see the record of rights of 839.
This is
836.
836, left hand side.
Record of right, Mr. Das.
But this is from the
What is this?
website, your lordship.
What is website? That is
previous-
তথ্য.
The,
But
the details.
No, I want the full record of rights.
If you Lordship kindly have a look, page 35. Canal Park. These all are Canal Park. My lord, I have 35. 835, my lord, job,
This-
page 34.
Show me the record of rights.
এই বাংলার ভূমি ওই দাগ নম্বরের ডিটেলসই পাওয়া যায় সেম
My lord, record of rights can be produced by the government.
Why you will not?
No, because I have, whatever document, my lord, I obtained, I have annexed.
No, what means no? Banglar Bhumi?
Yes,
Go there?
I have annexed this.
No, that this
that
is
is a
Kindly see
that is
this.
a portal. From there it is downloaded. Nowadays it is electronically available.
this is target.
হ্যাঁ এবার your lordship will see
the
that.
recorded owner.
Yes, these two, the private respondents.
Now this is said.
Your lordship will seize the.
No, this is bring it.
আচ্ছা ওটাকেই করে করা so that it is readily available. That barcode is usually given.
Hotel number 180.
ইরিগেশনের মাঝখানে একটা কি করে হলো
Take tips to get more information.
One thing may I point out, my lord.
186, my lord, I am on 135.
What that? Your representation is saying
836.
836.
835.
No, you're clearly 836. See your representation.
This is all.
And that
836, 835, 837, all are jobs.
836. You are concerned about 836.
836, it is belongs to the irrigation department.
How can you say so? See the record of rights. Take information from your client. This record of rights shows that it may be comprised in JOL. JOL cannot be a private property, comprised in the and recorded in the names of two persons. So how can you say?
That is my case, my lord. How, my lord, the government land has been recorded, my lord?
Go to Land Reforms Tribunal.
I cannot.
Yes.
Is the government to, my lord, approach to decide?
Why not? Why not? Government land, it has been wrongly recorded. This channel is completely different. Not this way. Neither this 62, 64, 71, nothing.
Yes.
If you want that, you take instruction whether you can fix up the land as a public land by any document. He is showing the record of rights. This 836.
Claim is that how, my lord?
Your
it has been
claim,
recorded?
no, this is not the forum. There's a completely different forum. Section 50 of the Bengal Land Reforms Act. There's a complete different way too. If you alleges this has been wrongly recorded, you want rejection, I can grant you liberty to go there. For correction of the record of rights, you can take.
আমি বলছি নাকি কি আশ্চর্য তোকে কথা বলছো তাহলে কর মামলাটা
without minor direction.
Record of rights shows. Now,
Now, my lord, in that event, your lordship can
go there and take steps for correction.
But it has to be given. Otherwise, my
Go there, take in accordance with law. The affidavit of service filed on behalf of the petitioner be kept with the record. The petitioners are alleging that the private respondent numbers 9 and 10 has encroached upon the public land. Now, encroached upon land belongs to irrigation department. Petitioners are praying removal of such encroachment from the said public land. Stop. Done an advocate for the private respondent number বলেছি তো 9 and 10 বলেছি produces the photocopy of the LR record of right of the subject land, wherefrom it appears that the subject plot number 836
It's comprised under Khutian number 118, and the father of the private respondent is the recorded owner there of the of such land. Inclusive definition of land includes everything. Deep and
I am only drawing your loss.
Stop. Mr. Acharya, learned advocate for the petitioners, submits that the private respondent has erroneously has managed to record the public land in he father of the private respondents has managed to record the public land in his name. If that be so, the procedure for correction of record of rights is required to be resorted to. The petitioners are always at liberty to do so. In view of the such factual matrix, in the backdrop of such factual matrix, the order for removal of unauthorized removal of the private respondents from the subject private respondents from the subject land is not warranted. Disposed of with the above terms.
You on page, my lord, I am just showing, my lord, kindly take double one. Page 37. Kindly have a look, page 37. Against my lord, the RTI. Against my RTI. Kindly see.
Information is not available.
Kindly see this. This is my lord, way, my lord, which is going.
Mr. Acharya, you know how these state machineries are now functioning. You know it very well.
We should not open my mouth widely. My lord, let the record of rights be, my lord, a copy be given to me. Otherwise, my lord,
Supply. Supply him a copy.
Not a big na. Big na. আমি তো সেটাই চাই।
রাখো বড়টা রাখো।
17
দাদা আমাকে একটা খাও। আচ্ছা ওই ফোন নাম্বারটা
The petitioner is a research scholar.
Huh?
He's a research scholar in Sanskrit, Pali practice. And she is working at present as a assistant professor in a college. And she got admission. She was selected through the national eligibility test and got admission in PhD Sanskrit under Vishwabharati University in the year 2018. Subsequently, the petitioner became pregnant. And she gave birth to child in the year 2021. And the research work to be completed within 2 years, but
Due to this pregnancy, she could not.
she could not
You want enhancement, extension of time.
extend the re-registration and extension of time. I made representation before the authority, but they did not respond to that.
Lordship, I am appearing on behalf of the respondent number 1, Lordship, and for respondent number 1, Union of India, Lordship.
Vishwabharati?
I have yes.
Who usually appears for Vishwabharati?
Service has been completed.
Niranjan, na? You serve either Niranjan Bhattacharya or Soma Majumdar, whoever. Come, not this week.
I'm Bekti appear for the petitioners, Lordship. Lordship, item number 18 and item number 37, Lordship, both the same matter. Lordship, this is a non-Jempers candidates matter, Lordship. Non-Jempers candidates.
I don't follow. What?
Non-gen first candidate
Oh,
have not appeared in joint entrance exam.
but what they want?
But they have already admitted and they want to proceed the case.
How can it be?
For the petitioners, my lord,
Who has got the, who has given this admission?
the university, my lord. My lord, the same set of matter, my lord, fixed, the item is appeared in page, in item number 36. In item number 36, my lord. My lord heard this matter on the last occasion. And but my lord, Mr. Nilotpal Chatterjee was appeared for the state and
In 36.
36.
Mr. Chatterjee appeared for the state, my lord.
These
For
two
the INC.
For the state university, my lord.
INC.
for the state, my lord.
State Nilotpal Chatterjee.
Well, the nursing council is not here, my lord.
In medical science, allied
Medical science,
nursing council is not.
37.
What is the matter about it? It said the JNM course scheme.
Yes, my lord. This is
37.
37. 37. Shubhashish Dev versus
দেখি order করা আছে কিছু একটা।
is my lord heard this on the last occasions. My lord, this is also the same.
Oh ho.
Yes, my lord. This petition.
This non-gen pass students.
37 is student of some other colleges and 18 is the students of some other colleges. এটা কোনটা?
Oh, university have the case here was for the college. Who appeared? You appeared for the college.
My lord. The case was that, my lord.
Same college.
No, my lord,
different
my lord.
college, my
This is a different college.
This is a different college.
18 is different college, but the matter is same.
You had sent the names of these persons in the college.
Was here, my
Yes,
lord, is 1 degree ahead, my lord. There are 4 students who have also received registration numbers.
In item 18, my lord.
No, my lord. That's not
Then
happened.
you have, if you have got the registration, what is your problem now?
The problem is, my lord, this is a half-done process they have done.
That
The
means-
university.
That means
My lord, my lord, may I just add the facts for once, my lord? May I, my lord?
no, register done, registration done.
In item number 18, out of the petitioners, out of 4 students, they have received the registration. They are also non-GenPAC students. The non-GenPAC stand, they have not appeared for the joint entrance examination.
Therefore, here in item number 18, 1 to 4 has got the registration.
1, 2? No, my lord, just, my lord, please.
Number
1, 2, 3. My lord, 1, 2, 3, and 10. 1.
Then why they have joined with them?
Well, because, my lord, the problem is facing the same problem, my lord. The non-GenPAC students, my lord.
But you have been already registered, at least 4 of them.
But
university.
Yes, my lord, that has been done. But the university is now reluctant to give the admit card and all. The problem is same, my lord, because the non-GenPAC student, my lord.
Is what is that you have sent the names of these students to the college. You have sent this. Why you have sent it then? If you think that they are not eligible to be get admission in the
They
course,
have also been granted scholarship by the government.
In half an hour
Acknowledging
before,
they
I
are
have
college
handed over the brief and I have not got the instruction.
understood? Let this
I'll
matter.
give-
I
for
think
the
my
case of
order dated 1st August 25 is explicit enough for your understanding.
In
So
case
this
of
team-
item number 37, that in that case of also those students we have recommended, we have under process of giving them registration.
Very well, then do it here also.
But in case of item number 18, we don't know what of the
Yes,
student
consider it. Now consider it in the like manner what I have directed in item number 37. You follow the same route.
My lord, probably the submission of my learned friend and the action of the university is contradicted itself. Because a letter has been forwarded by the university that they will not allow the students, the non-GenPAC students. And now the submission of my learned friend is...
They are under the process of...
Those students we have recommended.
Yes.
Earlier, in case of item number 37, we will taking in the process of for those students, and the rest of this work, in the case of item number 18, I have to take instruction because.
No, in 37, your stand was that non-Gen Pass candidates in previous academic session, the relaxation was made.
Yes.
Such relaxation is not available for
In-
the session for them. Now, in the backdrop of such situation, I've already held, you cannot deny the registration.
Yes.
College is directed to FM an affidavit
Yes, ma'am. The affidavit is ready, my lord, if your lordship.
detailing the procedure adopted to admit the petitioners and said course. Oh, I thought that first the college must disclose in which process.
Affidavit is ready. I have served them copies, my lord. If your lordship so desires, I can find it before you.
My lord,
In 37, I'm taking it.
37 in item number 37, probably, my lord, some other council was engaged on behalf of university.
I lead by my senior is there.
Oh,
Be that as
I
it
have,
may, whatever be the
Who is there for you?
I am behalf of the West Bengal.
No, who is your leader?
Devaki Nandan Maithis.
DN Maiti.
DN.
Where is he?
He is in Supreme Court for any another post. Yes.
So you file, you have seen that college has.
Yes, at that day, I was there in that matter.
No, the college was directed to file a report. I wanted to understand what is the method of admitting the students.
The key codes. My lord, I
It is
have
a
my
parameter.
affidavit. I have
Parameter.
given screenshots of the entire process of from the starting of register, login, everything. I shall demonstrate.
No, very well. Now, Mr. Shatra,
Yes, my lord.
now this college affidavit in item number 37 is there.
Yes.
You can now compare
Yes.
that whether they are eligible to get the registration or not.
My lord.
You respond to this. College has disclosed how the students were admitted in the college. Item number 37,
Item number 37.
right?
My lord.
So you file your response to this.
Well, within 1 week.
And similarly, in item number 18,
In that case, the college also informed that
you disclose what is the process of
the regularities.
file a report regarding the
different colors
and communicate to him so that a combined report he can come on the particular date with full information regarding these two states of it.
One indulgence, my lord, will it be the pleasure of your lordship to just record my learned friend's submission that they are on the verge of granting
No,
registration?
today it will not be just.
Lordship.
Then it will not be just.
Lordship.
Acha.
Affidavit copy.
Affidavit copy serve করা হয়েছে আমার কাছে একটাই আছে
My lord, I request kindly to note the submission of my learned friend on behalf of the college that the students who are before this court, the petition, or the students or the petitioners who are before this court, they have accepted the money as a scholarship from the government in this.
He has disclosed so in the affidavit, possibly.
So the scholarship part is not there because it is not. I am no party to between the student and the department, the government department.
Whatever there in the pleadings, Mr. Banerjee confine it with that. You are Mr. Orko Sen.
Yes, ma'am.
Mr. Orko Sen, item number 36-7 lecture. Mr. Orko Sen, learned advocate for the college, na?
Lordship.
On behalf of the college, files the report as directed by the order dated August 1, 2025. That it be kept with the record. The Mr. Ratra, learned advocate for the West Bengal.
সাপ্লিমেন্টারি এফিডেভিট না ও আচ্ছা এটা আমি দিয়ে দিই এটা তো দিয়েছি
University of Health Sciences
তো ও বলছে তো দিয়ে দিই
submits that
ইউনিভার্সিটি
his client shall file
আপনাকে সার্ভিস করা হয়েছে
file a response in the form of affidavit to the said affidavit
ইউনিভার্সিটি তাকে
on the next of hearing.
আমি
আরেকটা চাইলে বলো
Let such response be filed on the next date of their matter be listed on along with WPA 18734 of 2025. The college is required to file similar affidavit as has been filed today in the said matter also. The university shall file similar response to the said affidavit on the next date of hearing. The 60, these two matters will come in the list for analogous hearing. The affidavit filed by this matter, similar affidavit you will file in this matter also, because we need to know what is the process of taking admission of these students. Then you will have all information about the admission. Then you test it with your records whether it can be registered or not. They can. 16th September.
Yeah, grateful. I'm grateful.
16th September. Grateful, my lord.
Yes. Next one. Acha, ar ki dekhbo?
দুটোরই তো 1837 ক্লাব করে দুটো অ্যাকশন
আমাদের কি পরেরটা
Lordship, in this matter, Mr. Shantanu Kumar Mitra is appearing for the Higher Secondary Council, Lordship. Lordship, Lordship, due to some medical emergency, he has left the court today, Lordship. He has, few days back, he has gone through a eye surgery, Lordship, and
not this week. Not this week. It is that high.
That in a matter. Lordship, may I file the affidavit today?
What is affidavit?
Report.
No, he
Report in the
placed it
form
on
of
the
an affidavit.
previous occasion. My lord said yesterday. My lord said today. My lord will keep it. This
They will file a report and I.
Oh. It is really peculiar. I fail to understand.
Suppose, my lord, I have passed in first division. In 1996, I have passed in first division. Then the parameters were if you score 60 or first division. Now, can anyone, my lord, issue a notice said 96 to 2000? Anyone who will score 70 only will get first division. It is something like that.
And it is more serious than that. Maybe the yardstick is reduced for everyone. Understood. Now, if it's a subject which has been taken by a student, additional subject, whatever way you may,
studied it.
Compulsory
they have
subject, ma'am.
studied,
And I have to
they
pass.
have code. If the council is saying no, you have to take it, you have to pass it, but no credit will be given to you for your score. This is really peculiar.
Then why studying?
Impracticable concept. You know, it's not
What is the source? It is not the wish of the any person. Assessment regarding the assessment of mark, evaluation of mark, that must be guided by some rules and procedures.
Absolutely.
Find out
Regulation is there, my lord.
what would be the pass mark, what with the best of 4, out of 5, 4 will be taken up.
And more importantly, in my matter,
No, don't repeat. You are coming not within the zone of that.
they have withheld my registration.
Can you do that? He is not coming within the zone.
My lord,
Mr. Mito is not here.
From the back sheet of the mark sheet, my lord, it appears, my lord, a candidate to be declared pass, my lord, must secure pass marks in 2 languages, 3 compulsory elective subject, and environmental education.
That is in regards to 2011,
Yes.
I think.
I am also concerned with
Environment. But the environment will not
will
be
not
taken.
take in consideration.
My lord, there is a difference. The petitioner in the earlier matter, 19, was in the year 2000.
Yes.
My lord, as for those 3 marks, there was no total mark.
Grand total mark.
At that relevant point.
There was gradation back then.
And in the second repetition in the year 2014, there is awarded the total marks which is reflected from the mark sheet. At that relevant point of time, total marks has been calculated by the council and that is declared.
We are concerned about exclusion of a compulsory elective subject from the zone of consideration. What was the reason behind it? You are compelling a student that you have to study, you have to pass,
Compulsory, sir.
otherwise you'll be plucked.
Compulsory.
Into their memo, they have calculated the total marks out of 500. So if the two
No, calculating 500. Why any credit should not be given to the elective, compulsory elective subject? Supposing best of three, the three found to be less mark, automatically it will switch over. The best will come. That was the conception. Higher Secondary Council is to justify a particular year why they will read. Why? The Supreme Court has said that you have to read without any credit to go. Mr. Mitra said the only Supreme Court
Yes.
says that environmental science is to be
Included.
included in the curriculum. Very well included. As the Supreme Court says that even if he is taken by the student, the marks will not be credited.
But in 2025, recent the West Bengal Health Recruitment Board has issued notification for recruitment of nurse. Here also all the marks they have sought to upload the marks of all the subjects.
Now, what happened to that particular year?
Shall keep this on record? Your Lordship promised all of us yesterday.
দেখো দাদা দুটোতে আলাদা একটাতে দাও আরেকটা করে দাও একটা ফাইল দাও no you change your procedure whatever you but you cannot do anything with the detriment to the students.
With retrospective.
1 year, 2 year, they have read the subject. They have become so conscious about environment. Your education is so good, so practical. You made them very environmental conscious, and they scored well. Now you are saying no credit to it. Then what the student will do now? The seed he has planted, he will first come in the home, he will uproot that and throw it out. On behalf of the West Bengal Council for Higher Secondary Education, a report as directed by the order dated July 4, July 4, 2025 is filed. Let this report be kept with the record. ওটাতেও তাই করবে. You have to wait for some time. Let Mr. Mitro come. He is not well. This is personal difficulty. ওই ওটা করে দাও.
দুটোতেই ফাইল করেছে
না আলাদা আলাদা ওটাতেও রিপোর্ট আছে. আলাদা করো.
চোখে ওই
না উইথ করে আছে নাকি?
আজকে হঠাৎ করে নাকি চোখে
তাহলে দুটো আলাদা রেকর্ড হবে না?
Two separate matter, two separate reports.
তাহলে কি?
Yes, they put it.
কোনটা ইন WPA নাম্বারটা দাও? একসাথে রিপোর্টস বলে করে দাও। আর ফাইল্ড না ডেট কেন আলাদা হবে? হ্যাঁ সেম ডেটে অর্ডার হয়েছিল তো রিপোর্ট ফাইলিং এর 4 July, both in 4 July.
In my matter, your lordship has asked me to add party to the West Bengal Council. I have done that. But
council is a sub copy upon
I have already served. I have already served.
Report was directed on 4 July by order, the common order dated 4 July.
No, in my matter,
Possibly in the second matter, there is no direction for report.
Oh, no direction, na? On behalf of the West Bengal
প্রথমটা 4 July
Higher Secondary Council, a report is filed as directed document. Separate reports are filed in the matters. Let those reports be kept with the record.
We are grateful, my lord.
Returnable 16 September.
We are grateful.
Lordship was actually
Follow
16 September.
ও করেছে ফাইল রুম করে লিখে দিয়েছে